Good morning, everybody. Happy Super Friday. Welcome to the Courtroom Files Live. Anybody can have a Friday, but doggone it, here at TCF, it's all about having it be a Super Friday. So, bunch of judges just starting to get their day going. In the meantime, we'll go ahead and start with Mindy Glazer and Miami-Dade because undoubtedly there was some very, very bad, not good things that happened there last night, as is their usual arrangement.
Motor vehicle parts and criminal mischief. It says the four wheels of the rims and tires were removed in minutes. Damage, significant damage, $6,000. So count one, grand theft of motor vehicle parts. I'm setting that at $5,000. And count two, criminal mischief is $5,000 plus house arrest, level 3. With a curfew, 11 p.m. to 6 a.m. I didn't do enough for him. He has a probation hold. F-25-23123 was possession of fentanyl. I found probable cause for possession with intent to sell fentanyl. He had 2 grams of fentanyl in a scale. So count one is $7,500, and count two, possession of paraphernalia, is $500 with the probation hold.
House arrest?
Not on this thing, not this case. And then the last case, F-25-23121, is burglary to the unoccupied conveyance and grand theft. So here he goes to somebody's truck and removes a blue ATV and tries to start it, but he couldn't start it. And then he pushes the ATV eastbound down the street. There's probable cause for burglary and grand theft. So count one is $2,500. Count two is $2,500. This one is plus house arrest, level 3 curfew, 11 p.m. to 6 a.m. And you'll see your judge tomorrow. Monday. Have a nice day. All right, moving right along. Raymond Barrett, page 17.
No, Your Honor. Number 48, Arguello Masses.
Okay, they didn't give me that one.
I think.
So I'm sorry. Let me go make sure we pull all the numbers right.
Yeah, 48 is Arguello.
You have number 26, number 36, number 41, number 48. Why is it? Why that does not surprise me, but it's okay. You're sorry.
We didn't do number 36. 1 second.
Don't stop drinking that stuff. So I need 26, 36, 41, 48, 50, and 51. 1, 2, 3, 4, 5. Oh, that could be the lottery numbers too. It's 6. Is it 5 plus 4? 6, I don't know. So who's next, please? Okay. What number is that? Pablo Fonseca, number 36.
Number 36 on page.
Silvio Arguello Mathis, page 17. Are you Fonseca?
Yes, ma'am.
This is Fonseca.
Good morning, Your Honor.
Good morning, sir. You were arrested for 2 cases. It says added charges. Retail theft with multiple locations. That's from August 31st. And then retail theft, multiple locations.
Fonseca.
What?
We are on Mr. Fonseca. I don't think you can hear us very well. I'm not sure what the volume is over there. I think there's a Zoom issue with the volume.
No, I hear you perfectly fine. He numbered my calendar wrong.
It happens.
He just said he wanted Arguello Mathis. Somebody said that. What page is he on, please?
He's on page 12, number 36. Pablo Fonseca.
We're only at number 36. All right. But it might not be my number 36. Okay. Good morning, Mr. Fonseca. You were arrested for armed possession with intent to sell cannabis, possession of cannabis within 1,000 feet of a school, and tampering with physical evidence. So, did you hear? Tell me. And so I'm appointing the public defender's office for you.
It's a traffic stop.
I need to get the paperwork.
Alrighty, just so you know,
Thank you.
I don't see a way.
So do me a favor. We're going to sit tight a second while I find out my paperwork. Okay.
Okay.
Everything's not good. All good. Well, I got it right here. I guess. Let's just relax. Everything's cool. All right. So I got your arrest affidavit. Let me review. He's, I guess, is he speeding in that school zone? Oh, boy. He's going 30 miles an hour in a school zone, endangering the lives of children going to school. So he gets stopped. His odor of cannabis emanating from the vehicle. He had multiple bags of cannabis, a cigarette, marijuana cigarette, THC, a bag with cannabis, a scale used to weigh it before selling it. I'm glad that they added that in so I know what the scale's for. There was a black gun in somebody's backyard near where he got stopped. They think he threw the gun there. There's probable cause for that. There's probable cause for the charges. It is a traffic stop. He's 25. So I'll set it off.
He remind me all of his life. He works 7 days a week at a car wash.
Okay.
He like,
Count one in possession with intent to sell cannabis. I'll set that at.
Judge, there's no way.
They have multiple individual bags of cannabis, a marijuana cigarette, THC, and a scale. Because of the scale, I think it's enough for that. Count one armed possession with intent to sell cannabis. I'll set that at $1,500. Count two, the possession of scale. I agree with you on that. It's stop within the school zone. No probable cause for count two. It's just the possession of cannabis for count two. I'll do an armbar for count two. Count three, there's probable cause for tampering with evidence, $2,500. So you can post the bond and get out of jail. Let me see. Yeah. Does he have money to post the bond? I don't know. Is he free trial? Okay, not with the sale.
Yes, Judge. Yes, thank you.
Okay, have a nice day. All right, so next, number 41, just give me the name so I don't have an issue. We did Mr. Lopez already. What about 48?
Is Silvio Arguello Masis.
That's the one we called before, pick number 7. I don't know what page, 17?
17.
Is he coming in? And also I had to stay away when I don't see it.
Spanish, please.
1 second.
Señor Argüello, ¿habla inglés?
Spanish.
Good morning,
Yeah.
sir. You were arrested for 2 cases, retail theft multiple locations, both from August. I will appoint the public defender's office for you.
Your Honor,
Señor, le han puesto cargo por ratería, por 2 casos, ratería de tienda en varias ocasiones y ambos fueron en agosto. Le voy a nombrar abogado de oficio para que lo represente, que está a su lado.
Fugitive hold from Broward, and he is, has a hold for immigration.
Él tiene una retención migratoria y también del condado de Broward.
Okay. Only 3 deputy? I thought there were 5. No. Oh, okay. Thank you. Thank you. All right, so let me review. There's probable cause on F25-23243 for retail theft. It's alleged he and a friend stole over $1,100 of cosmetics from CVS.
Sí, entonces hay motivo fundado por F2523243 por ratería de tienda. Se alega de que él se robó $1,100 de cosméticos de CVS.
It's a $2,500 bond, and you're ordered to stay away from the CVS at 4000 Collins Avenue in Miami Beach, Florida.
Es una fianza, le han puesto una fianza de $2,500 y tiene que alejarse del CVS que queda en 1000 Collins Avenue en Miami Beach, Florida.
And for the other case, you were ordered to stay away from the CVS store at 555 Washington Avenue in Homestead, Florida.
Entonces, el otro CVS tiene que alejarse del CVS que queda en
No, it's Miami Beach. It's Miami Beach.
555 Washington Avenue en Miami Beach. Okay.
You're not allowed to go to that location, and you must stay away from it.
No puede acercarse a ese local y tiene que alejarse de esa tienda. ¿Está bien? ¿Entendido?
Here he's stealing $1,600 of merchandise.
Y en ese se robó 1,600 de mercancía.
Setting the bond at $2,500 on this case as well.
También voy a fijar una fianza de $2,500 en este caso igual.
And that's it. You have an immigration hold. Have a nice day.
Eso es todo por hoy. Tiene una retención migratoria. Que tenga buen día. Ya puede tomar asiento.
Okay, corrections. Who do you want next?
Paul Alcott, page 18.
Right. Paul Koch, page 18. He's number 51. Give me a second. Finish up this. 1 minute. Good morning, sir. Mr. Koch, you were arrested for, it says added charge, 71 counts of making or throwing a bomb or destructive device. This is from August 14th. So I will appoint the public defender's office for you. Corrections, one other thing. Do you have Mr. Lopez there still? My clerk left a whole bunch of stay away orders they didn't give me.
do you want to just have him read in division, Judge?
No, 'cause
Fine with that, Judge, based on the charges here.
is he still there or no? Can you get it back so I can read these like 15 stay away orders so I don't have to just waste these poor trees getting killed? Sorry, Mr. Koch, let me review this for probable cause. 71 counts, let's see. Okay, it looks like, I guess his family members found these devices, 71 devices labeled either explosives or smoke in the house. They called the police, and he's been in jail. They were suspected explosive devices. So 71 pipe-style explosive devices that were secured by the police. 17 of the devices had fuses, 54 were not fused. But the devices not fused had holes drilled in the end caps ready to be fused. And they were filled with powdered and metal pellets. So 18 came and collected it. They have lab test results that showed mixtures of sulfur, phosphorus, pentabromide, potassium nitrate, and black powder. You too, Deb. All right, so they also found other ingredients, I guess, used to make these explosive devices. Lots of ingredients. There's probable cause, I believe, out of state. Ms. Corey, do you want to say anything?
Judge, my understanding, Mr. Coach has been in custody for almost 8 months now. There's nothing indicating he was one that placed any of these items into the home.
Yeah, he's charged with murder.
There's nothing indicating that he created anything listed in this arrest form.
Oh, there's probable cause for the charges. I'll set a bond on counts 1 through 71. These are all third-degree felonies. I'll set the bond at $5,000 each count. I think an increased bond is warranted based on the nature of the items discovered by the police. $5,000 bond each count. All right, good day, sir.
Well, that is an allegedly upstanding citizen. Good morning, everybody. Happy Super Friday. Welcome to the Courtroom Files Live. Let's stay in Florida, but let's go to Wade Mercer.
And if we have a tall person, anybody close to 6 foot or over, we're not gonna be able to see their. That's fine. That's better. So we only have 2 cases this morning. We have Anthony Sawyer first.
Yes, sir. The other one, he's already gone to Holmes County, the Yates.
Brandon Yates had already been transferred. Sounds good. Mr. Sawyer, good morning. Mr. Sawyer, you've been accused of, good morning. You've been accused of 1 count of aggravated fleeing and eluding. That's fleeing and eluding at high speed. You also been accused of 1 count of tampering or destroying evidence. That's a 2nd-degree felony and a 3rd-degree felony, Mr. Sawyer. I've read the complaint. There is probable cause. I've also looked at your criminal history. Mr. Sawyer, it looks to me like, according to the Department of Corrections website, you've been to prison 4 times and you most recently got out this April. Is all that part correct about the criminal history, Mr. Sawyer?
Yes, sir.
Let me see if the attorneys have any additional information they want to make sure I'm aware of, Mr. Sawyer, before I set you a bond. Mr. McDaniel?
No, Your Honor.
Mr. Gill?
Yes, Judge. The state is showing that he was released from prison back on April of this year. I've also reviewed his criminal history, and it appears that he would qualify as a habitual felony offender for this offense, making the aggravated fleeing and eluding a 1st-degree felony punishable up to 30 years in the Florida Department of Corrections, and the tampering would be increased to a 2nd-degree felony punishable up to 15 years in the Florida Department of Corrections if he were designated and found as a habitual felony offender. The state would argue that the weight of the evidence is great in this case based on his statements and where he was found and located. And based on all that, Judge, we're asking for a high bond and that he also be subject to random UAs.
Thank you both. So, Mr. Sawyer, the other concerning part, in addition to what Mr. Gill said, is the speeds you allegedly were going. They're saying you're going over 100 miles an hour on 3 different roads, and those are some of them are dirt roads that have residential in nature. The allegations are very concerning. I'm going to set your bond at $50,000 on the 2nd-degree felony aggravated fleeing and eluding, $10,000 on the 3rd-degree felony tampering. Your total bond, Mr. Sawyer, is $60,000 cash or surety. Mr. Sawyer, you can go through a bondsman. You will get use the phone in a few minutes, sir, to try to post the bond. And you do have the standard condition because because there's an allegation of drug use, you do have a standard condition of random urinalysis. So $60,000, but you go through a bondsman, they may charge you 10%, they may charge you less than that. That's between you and them, but you do have that right. Lastly, Mr. Sawyer, we're going to ask the jail to give you a notice for your court date. I believe that's going to be November 4th at 8:30. They'll give you that notice after court this morning, but you did make the cutoff for the November 4th arraignment or pre-arraignment date. We'll see if the state takes time to file information by then. Mr. Sawyer, do you have any questions?
No, sir. I just, no, sir.
Wish you the best, Mr. Sawyer.
Thank you.
Yes, sir. Mr. McDaniel, if Mr. Yates has already gone, I believe that's it for first appearances this morning. Anything else from the public defender's office?
Nothing else, Your Honor.
Well, that was short and sweet. Let's stay in the 14th Circuit, but we'll go say good morning to Brantley Clark. He's doing felony hearings.
51849. And we are here on a motion to reinstate her bond. And what happened in this particular case was that Ms. Jordan was originally arrested on June 20th and was released on a bond. And on July 21st, she missed her court date, and that seemed to be because of a miscommunication with her bondsman. And so in this case, I'm just going to call Ms. Jordan as a witness, and I believe. Okay, so Ms. Jordan will be the only witness.
Solemnly swear the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes. Please give us your full name.
Bianca Jordan.
And Ms. Jordan, tell us what happened with the bond situation.
I had contacted Billy Clark about my bond situation once I found out I had missed court, and he told me it was a technicality on his behalf that I was fine and to turn myself in, and he was gonna reinstate my bond and bond me back out. So I was trying to turn myself in on that Monday. I think it was July 28th. I was headed to the jailhouse to turn myself in, and I did get stopped like on Star Avenue and 231. And I was telling the Officer McGee, that I just talked to my bondsman, and he know that I was on the way to turn myself in so he can reinstate my bond and bond my bond so I can bond back out. And then I talked to Mr. Donaldson about this situation.
Right. And so if your bond would be reinstated, do you have a place to live?
Yes.
And where would you live?
Here, 421 Sims Avenue with one of my best friends here.
And do you have a job?
Yes.
And what type of work do you do?
Self-employed. I do hair and I own a food truck.
And now you understand that there is a no contact order with your children. Will you be able to adhere to that?
Yes.
And so they wouldn't be living with you while this is pending?
No.
And other than this particular failure to appear that happened with the bondsman, have you had any previous failure to appear?
No.
And do you have a previous criminal history?
No.
So this is your first time where you're in real trouble?
Yes.
And that's all the questions that I have.
Mr. Ferrer?
I don't have any questions, Your Honor.
Ms. Benton, call your next witness.
We don't have another witness. I would just like to bring to the
They have
attention.
your witnesses? Okay.
I just would like to bring to the attention that Ms. Jordan does have family that is supporters of her, in addition to her being self-employed, and that she has the score sheet also shows that there is no criminal history. And at this point, There's no indication that she's a danger to the community. She tried to turn herself in. And we feel that she's a good candidate to have a bond reinstated. And I'm sure that this time that she spent in a jail has made her aware of the importance of adhering to her court dates.
Yes.
State's position?
The state's fine with reinstating the bond. Just to reiterate the no contact provision with the children. It's essential that she not have any contact with the victims in this case.
All right, based on that, I'll grant the motion, reinstate the bond. You'd have absolute no contact with any of the alleged victims in the case. If you do, that can also, a capious can be issued for that also for a failure to abide by the no contact order, and you can be held without bond, and I won't consider another bond.
Yes, sir.
Consideration. You understand?
Yes.
All right. So it'd be up to the bondsman whether to do what they want to do as far as, but I'll reinstate the bond. Anything else I need to do on that, Madam Clerk?
She's another court date.
Oh, yeah, we'll give her another court date, and
We have depositions on Monday on this case, right?
do you think she's bonding back out, Ms. Bennett?
Pardon me?
Do you think she's bonding back out?
I
Let me
don't
do
know.
this.
I'm going to
right
contact
now,
her
I'm gonna set
bondsman and see where he's at with that.
For November 20th at 9 o'clock, that's an in-custody hearing, pre-trial. If you bond out, you need to stay in contact with Ms. Bennett. Make sure you have a good address with the clerk's office. And regardless of that, I'd check with Ms. Bennett in the clerk's office and make sure when my next court date if you get out of jail. You understand?
Yes, sir.
Okay, good luck. Or
I'm gonna call
in
you
the
back.
alternative, be here on the 20th, whether you're in custody or out of custody.
You make sure that you call me if you're released, okay?
Okay, I will. Thank you.
That's all I have this morning. Thank you.
Okay.
Ms. Peskin?
Morning, Your Honor.
Good morning.
I have Stephen Flagel on the trial management docket this morning with Mr. White.
That's this afternoon.
Oh, I'm sorry, Your Honor.
That's all right. Go ahead.
I think we're ready for trial. I'm not sure what Mr. White's position is.
Mr. White?
I have two cases that have sent subpoenas out that I'm preparing for trial on, and after speaking with Mr. Sullivan and with Mr. Ferreira, I don't think we're gonna have room for this case on the trial docket next week.
All right.
Or on the 3rd.
Ms. Peskin?
I guess I'd like to leave it on the trial docket, Your Honor, but I guess at this point, if it's not going to make it, then we should continue it to the next.
You don't want to leave it as a backup?
Have a seat. I have two cases for backup if we could continue it to December.
Oh, they're already back up? Your two are already back up?
Well, I have one that's definitely going and I have another one that's a backup.
Okay.
That's fine.
All right. You think on December, we need to go over the first year? Mr. Meredith?
I'll leave that up to the defense.
It's up to you. I don't care where we put it. December's fine.
Okay.
All right, Mr. Meredith said his backup's not going because he's got family issues.
Okay. The state would still ask to set it for December 1st.
That's fine, Your
All
Honor.
right, December 1st at 8:30, November the 21st at 1:30 for trial management.
Next, I have Jesse Baker. This is a motion for peaceful contact. I believe the alleged victim in this case, Ms. Jones, has had contact with Mr. White as well.
Mr. White? This is Baker. This is a motion for peaceful contact with the alleged victim in the case. Have you had a chance to review that motion?
I've had a chance to speak to the victim and the victim does want to have the peaceful contact with, or wants to have peaceful contact.
Then there's no objection from the state?
No objection, Your Honor.
I'll grant them. I've reviewed the motion prior to coming to court today. Also, the probable cause affidavit. I'll grant the motion for peaceful contact, but peaceful contact means peaceful contact. And if there's any violations of that, that could end up in a revoking of the bond.
Yes, Your Honor, and I'll submit an order on that. Next, I have David Dominguez. This is a motion for early termination of probation. I believe he's here. Yes, come on up, Mr. Dominguez.
Has the state reviewed that motion? Any objection?
Yes, Your Honor, he violated, I believe it's a violation hearing. I originally asked, if I remember correctly, Mr. Dominguez opened play. I believe I asked for a prison sentence and he was reinstated. So at this time, I'm asking that he.
That was a violation of changing jobs without letting the probation
I
officer.
believe that's correct, Your Honor.
Something along those lines, Your Honor, yes.
All right, you can call your first witness.
Your Honor, can I call Mr. Dominguez? I
I do.
Now, you had a violation of probation back in March of 23. Is that correct?
Correct.
All right. And you entered an open plea to this court and were sentenced to 2 years sex offender community control with the balance to be regular probation. Is that correct?
Correct.
And you've done all of the conditions and have completed at least half of that sentence. Is that right?
Yes, ma'am.
All right. I don't have any other questions, Your Honor.
Mr. Sullivan? Has he completed all the community control?
Yes, Your Honor, he has.
It ended in May.
So he's had no violations for almost 2.5 years.
That's correct, sir.
The only violation was, if I remember correctly, was a job that he didn't, it was a job from one restaurant to another.
Yes, that's correct.
Mr. Sullivan, are there any conditions that have not been completed?
Looks like. I don't see anything added.
Well, I'm reviewing and these are serious charges, and I understand that, but I believe they're all 3rd-degree felonies. And I have reviewed the old score sheet, lack of a prior felony record, that he did make 2 years community control. The only violation was that failure to.
There actually was a second violation.
What was that?
It was in 2022. Went to a violation in February of 2020.
Let me see what that affidavit is.
Violation report was filed on.
I've got it just buffering right now, but I got it coming up. The changing his residence without. All right. But he's been on supervision for.
Yeah, since November of 21.
21. So I'm gonna grant the motion at this time.
Thank you, Your Honor, and I'll submit an order on that. Next case I have is Ryan Martin, Your Honor. This is also a motion for early termination. He entered a plea on June 6th of 2022 and has completed half of the term and has met all of his conditions as well.
All right. State's position. And there are no conditions left to be done.
No, Your Honor.
He's also served 3.5 years on that also. Is that correct? He has about 1.5 years to go. So based on that, I'll grant the motion for early termination.
Thank you, Your Honor. And then the final one that I'm handling this morning is Jason Wasserman. We had filed a motion to withdraw as counsel. He failed to appear for jury selection and we've had no contact with him.
And we have a warrant outstanding for him.
We do.
Yeah. I'll grant the motion to withdraw.
Thank you, Your
based on
Honor.
that. And then we'll take it up when he's ever in custody.
All right. I believe Mr. Shepard's going to cover some others of ours this morning.
Okay.
Thank you.
All right, we'll keep an eye on Judge Clark's court. Let's go up to Michigan. Judge Anzalone, I believe she's going to do a sentencing.
Dwayne Moe, file numbers 24-21931FH and 24-22090FH. Rhonda Underwood appearing on behalf of Mr. Moe, and Ms. Holly is present in the courtroom. So Ms. Underwood, have you had a chance to speak with Mr. Mo?
I have, Your Honor.
So, Mr. Mo, you have had an opportunity to read and review the pre-sentence report.
Yes, I have, ma'am.
All right, and you've had ample time to discuss that with your attorney.
Yes, I have.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, I am.
All right, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Not really, Your Honor. There's just a lot that Mr. Mo would like the court to understand about his circumstances. And that this started out with that he was not given his transfer papers to sign. And then transportation became an issue, a serious issue. He called and tried to resolve that, but he wasn't able to do it. And then he got in a situation where he was just scared. I mean, he didn't start out not wanting to complete this, not at all. Okay. And I think the probation report kind of makes it seem like he did.
Okay, okay. Mr. Mo, is there anything you want to say? Are you here on Mo? No. What are you
I'm
here
here.
for?
I'm not here for this one.
Okay, all right. I'm sorry. I was speaking to Mr. Hartung, a prosecutor, Mr. Mo. Sorry. All right, Mr. Mo, is there anything? All right, my computer is shutting down and restarting, and I don't know what's happening. Okay, so Mr. Mo, is there anything you'd like to say on your own behalf?
The only thing I have really say on my behalf is this is the first time I ever had leniency.
I have more to say, Your Honor. I'm sorry. I have more to say to allocute for Mr. Mo.
You know what? I'm sorry, Mr. Mo. I really thought Ms. Underwood was done talking, but let's let her finish.
Thank you. Your Honor, this is Mr. Mo's first violation. It is a failure to report. It is not a new crime. It is nothing like that. I understand that Mr. Mo completed 365 days in jail.
Rhonda, stop for a minute. Stop for just a minute. Like, I don't know what's going on with my computer, and I'm sorry, but it's like, yeah.
But mine's doing the same thing. It keeps going black and back on. I don't know what's going on.
All right. I'm gonna call your brother. In IT. Hey, Derek, it's Judge Anselon. So I'm on the bench. My computer, Becky's computer, like this, it's almost like you're logged on and closing out all my screens and playing with it. So you think you could, and I'm trying to do sentencings, but I didn't know if you could like actually log on and see what's going on.
I think it's taking updates.
No.
Yeah, I seriously do.
How do I stop that?
I don't know if I can. I'm almost 100% sure that's what they're doing, because I did that yesterday.
Is it gonna do I just?
It will automatically, it'll finish, it'll just stop blinking. Is the screen still like blinking on you?
It's not right now. So, yeah, because my peripheral screen would shut off. Oh, no, it just said the system has been updated.
Okay.
So I'm done?
Good sign. So yeah, it should be done.
Okay.
I can look, if it does it again, because there's a big display out there in the last update, so that's why it messes with your displays.
Is that why my Zoom's been acting up?
Yeah, probably not. Why Zoom is acting up?
I'll send you those screenshots. All right.
Yeah, that'll work. Do that and I can look at it, Judge, and I'll let you.
Okay, thanks. Bye.
Yep, no, bye.
All right, so my screen looks normal now, Rhonda. Proceed.
Thank you. Mr. Mo, I understand, has done a great deal of jail, 365 days. I hope we can find an alternative for Mr. Mo to prison, Your Honor, because I don't think this Mr. Mo really belongs in prison for this violation. It's a first violation, and it's failure to report, Your Honor. That's what it is. So, I know he has jail available on one file, and we would ask that whatever the court does, Mr. Mo gets full credit for all the jail he's done. I know there are 2 different jail amounts. One on the 10-year and one on the 5-year, 4-year.
Okay, sorry, my computer just like did that thing it does again. Okay, so going at. All right, so he has 140 days jail credit on one file and 365 on the other still, Miss Holly, or do we have?
First violation is arrested. I need to buy a mic.
Joanne, we can't hear you, not by a mic. Can you scoot up by a mic?
I'm sorry.
Thank
Plus
you.
whatever he served for being this arrest. He got arrested on 10/7.
And I might point out that the recommendation is to the high end of the guidelines, Your Honor, for 3 years. It's more appropriate, I believe, if there is going to be prison time, that it be to the low end of the guidelines, Your Honor, which would be the 19 months.
So 16 days violation.
16?
Yes.
All right, so in 24-22090, he's got 156 days credit.
Yes. Yes.
And then on the other file, he will have 365 plus 16. My computer's just like going on and on.
381.
381. Okay, Miss Underwood, my computer keeps going on and off. It's not impacting what you see, does it?
No.
Okay.
Everything looks totally normal on mine, knock on wood.
Okay.
Same here.
Thank you. Okay, great. All right, and there was $10,700. Look at this stuff. In restitution. All right, I'm sorry. It's just like flashing back and forth. All right. Okay, anything else, Miss Underwood?
No, Your Honor.
All right. All right, Mr. Mo, anything you want to say on your own behalf?
Yes, there is, ma'am. This is the first time I ever had leniency, ever be in trouble. I've never been on probation. I always been sent to prison, on parole. That really has not helped me out. Probation, I know, is a lot stricter. It's more, and I didn't want to mess this up. I did call when I first got out. I did call again, say I don't have a ride. My sister's only ride I have is my sister. I'm not trying to call the people I used to hang out with. Hey, give me a ride. You're a felon. Give me a ride. I'm not trying to do that. I'm trying to be good. And I didn't want to mess this up. I really didn't. I was just going through I had a lot on my plate when I first got out. That's all I got.
Okay. All right. I mean, you've been on probation before because you've had probation revoked on different things.
Parole.
You did when you were younger. Your record's pretty long.
This is. You can see the probation I never last long.
Now, where's your sister living now?
She lives in Tecontra. And she never moved to Pennsylvania. I never said she moved to Pennsylvania. I said she went to Pennsylvania for a week. That was my ride. I won't have a ride for a week. And she insists that I come 2 days later. That no, I just told her I didn't have a ride till next week. But she lives in DeConcha, Michigan, and that will be my address, DeConcha, Michigan.
All right. All right, it's a sentence of the court. You know, you got out of jail and you just dipped out on us and we never saw you again, which you have kind of a history of doing, but we have pretty substantial restitution on this case. So that's a concern. And when you go to MDOC, you tend to get a lot of tickets. So, what I will do is on file number 24-21931FH, I'll give you credit for 381 days. I'll continue your probation. On file number 24-22090FH, sentence the court to serve 1 year in jail. I'll give you credit for 156 days already served. When you get out of jail, I don't care if you have to sit in front of the building the whole weekend to report to Miss Holly, you will. Otherwise, if we have to issue a warrant for you again, understand you will go to prison.
Yes, ma'am.
All right, you owe $10,700 in restitution. I'm more concerned about that. I will say that if you pay the restitution of $10,700, you can be released from the Lenawee County Jail. I don't think that's probably going to happen, but if $10,700 is paid, you can be released from the jail. Otherwise, you'll serve the year with credit for time served and your probation is continued.
What's his address gonna be?
Yeah, what's your address at your sister's?
It will be 203 North Main Street, DeConcha.
Concept, C-O-N, huh?
T-E-C.
I don't get that. What?
TConcha. All right, so it's T-E-K-O-N-S-H-A, Michigan. Yeah.
Okay, zip code
49.
and your phone number? Okay. Who's your sister?
Yes, that's my sister, Carrie Moe.
What's her name?
Carrie Moe.
Terry with the T?
Carrie, K-A-R-I.
Okay.
Okay.
All right, understand if we have to hunt you down again, though, you will go to prison. So I would like you to get out when you're done and get a job and start paying down that restitution. You do have the right to appeal this sentence, so we're going to give to you at the jail 3 copies of your notice of right, 2 appellate review, initial and date, 1 copy for our records to acknowledge receipt of the paperwork. The other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Anything else, Ms. Underwood?
Your Honor, just to clear up, is probation only continued on the first file?
No, because restitution's on the other file.
Oh, okay. Okay.
Okay.
So I got
All
a
right.
year.
You got a year with your credit for 156 days. So, yeah, the guidelines are actually higher on the first file, Ms. Underwood. So I want them to keep on probation on that one. All right. Good luck to you. Thank you.
Thank you.
All right, my computer's not doing weird things. Okay. Underwood, is that?
So we talked in the pre-show about how the internet was broken. Right there is an example of said. It's good to know it's not just us. Let's go back to Judge Glazer. Honestly, it's a quiet morning out in the Courtlandia at the moment, but Things will pop up as we go, but let's go back to Glazer for now.
Aggravated battery on a pregnant victim and battery. All right, so whose phone is ringing like that? It's yours? Put it on silent or put it somewhere else up to hear it. Pause every minute. Okay. Let me see. Oh, we found a phone here. 2 phones.
Bailey gifted 5 memberships. Thank you so much, Bailey. I appreciate that.
Phones. What do I get at Walmart? $300?
Probably.
It's somebody maybe from the clerk. Tony, we have 2 phones in here that don't belong to us. If there's a, come claim them, I'll give them to security, but they're buzzing and driving me nuts. Somebody from the clerk? I think it's the clerk. I don't know. I'm gonna put them on the floor so I can have shaking buzz. Eesh. Anyway, sorry about that. So I'm just looking here where it says if you knew the victim was pregnant, it says he should have known she was pregnant. It's a visible bulge. Okay. So on this case, F25-23183. Well, let me read off the other ones too, so I have to keep repeating myself. All right, so there's PC here. Yeah, the other case F25-23183. I guess it's 2 incidents on the same day.
Yeah.
That's the problem. All right. So it's also aggravated battery and a pregnant victim battery. All right, you are ordered to stay away from the alleged victims. Liz Hernandez and the victim MAGM and Pedro Rangel. No contact with these alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victims through social media or other electronic means. And you must stay at least 500 feet away from the victims, their home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. You may return to the victim's residence 1 time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order? Yes, sir.
Got it. The victim is my sister.
I know. We know. You can't go back to the home while the case is pending. Speak privately with Mr. Hernandez, okay? You got to see the judge on Monday since you have an open case. What is it, open probation or bond?
Out on bond.
Is that on?
We had an articulation today.
What do you want me to do for bond?
The standard bond.
All right. 1 sec. So on F25-23183, count 1, aggravated battery on a pregnant victim is $7,500. Count 2, battery. is $1,000. And then F25-23184, it's 75, it's aggravated assault with a deadly weapon. I think pushed a pregnant victim. 1 minute. Is probable cause for aggravated assault with a deadly weapon. 5,000 count 1, 1,000 count 2. Okay, you have a good lawyer. Listen to what he tells you, and you'll see your judge Monday.
Judge, thank you. Judge, will I see?
Okay, let's change it up. We're going to go up to Michigan and Judge Elmore, who has just started his day. So let's see what's going on there. As soon as I get it queued up. Here we go.
Stepped on my court. I would have done.
All right.
I'm all set. Thank you.
All right, thank you. We are on a record now today for the 28th Circuit Court here in Wexford County, and we're taking up the case of People of the State of Michigan versus Dustin Lee Taylor. This is case number 24-13871-FH. Here in the courtroom with me is Mr. Kevin Stapleton. He is an agent from the Michigan Department of Corrections, serving as a probation officer today on the file. Joining me via Zoom are the counsel on the case. I've got Mr. Ryan Ziegler, who's a special appointed prosecutor from Kalkaska covering on this case. Mr. Ziegler, are you able to see and hear the court?
Yes, Your Honor.
Yes. Also joining me this morning is Mr. Poraya Niegos. He is the appointed defense counsel appearing via Zoom. Mr. Niegos, are you able to see and hear the court?
Good morning, Your Honor. I am. Thank you.
Great, thank you. All right, we're here today for, looks like a probation violation hearing. I think we're set today for an informal hearing. We've got, I've got a formal. Why don't you guys go ahead and tell me what's going on today? Mr. Ziegler, do you know? Are we running a hearing?
Your Honor, it's my understanding that there is a plea agreement that has been reached in this case. It is, Your Honor.
Nope, you guys got it. Go ahead.
Mr. Ziegler, in all fairness, and I wanted to put this on the record formally, hopefully it came through an email as well. When Mr. Fowler and I handled the underlying domestic violence case, it was handled by the Wexford County Prosecutor's Office. Mr. Carnes handled that. I asked Mr. Carnes to speak with probation to see what their position would be on the probation violation. Should Mr. Fowler take responsibility on the new file? Would they agree to dismiss the non-technical piece in exchange for him pleading to the technical piece? Mr. Carnes confirmed that probation was in agreement with that. As I was doing all this wheeling and dealing, it was an oversight on my part that Mr. Ziegler was actually the specially assigned prosecutor for the probation violation piece. And then I reached out to Mr. Ziegler. I believe he's in agreement with that negotiation that I more or less conducted outside of his presence, for which I apologize again. It was certainly not an intentional act, or it was just an oversight on my part. So my client is ready to, with all that said, my client's ready to plead today to the two technical violations.
That's all correct. Mr. All right, hold on. All right, so I've got Mr. Stapleton here in the office. This is a decision really to be made by the prosecutor, Mr. Stapleton. Did you have anything to add?
I've never been contacted by anyone in regards to this. I'd rather you plead to non-technical.
Okay. So just it maybe talk to somebody else. I don't know, but that's okay. Let's go ahead and see. Let's turn to the prosecutor. Mr. Ziegler, is it your understanding the defendant's going to plead today to count 1 and 2, and then in exchange, I guess regardless of whether or not Mr. Stapleton is in that position to support it, is that what your understanding is?
That was my understanding of the agreement that was reached between Mr. Nagos and Mr. Cairns, Your Honor.
All right, thank you. For the record, it's Carnes. We're not going to flog you, Mr. Ziegler. We'll accept it. All right, good enough. Mr. Fowler, is that how you wish to resolve this?
Yes, Your Honor.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do, sir.
You may lower your hand. Now, Mr. Negos, was there a domestic violence charge made in a new case?
There was, Your Honor. My client's already pled and has been sentenced on the new case.
Copy that. All right, so Mr. Failer, looks like Judge Fagrin covered the arraignment on this in my place. I'm just going to highlight for you. Count 1 alleges the violation condition 4.18 that you must not engage in any assaultive, abusive, threatening, or intimidating behavior. And more specifically, it's alleged that on or about September 25th of 2025, you assaulted Chelsea Aarons Smith. Count 2 is an allegation that you violated condition 2.4 that you must not use or possess any controlled substances or drug paraphernalia. And more specifically, it's alleged that on or about September 24th of 2025, you used methamphetamine. I assume that was evidenced by a positive drug test, Mr. Stapleton?
That is a positive drug test, yes, sir.
All right, thank you. Each of those two allegations are the ones that I anticipate you're going to enter a guilty plea to. They are each what are called technical violations. Mr. Stapleton, have there been any other technical violations in this case?
No, Your Honor.
Thank you. That means that the most the court can add to your sentence would be up to 30 days. If you do plead guilty to those two and the court accepts that plea, you'll be resentenced on your original offense. In this case, you were originally convicted of possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. Now, there is a third count, that is count 3, that alleges that you violated condition number 1, which requires that you are not to violate any criminal law of any unit of. And more specifically, it's alleged that you committed an act of domestic violence on or about September 25th of this year upon Chelsea Aarons Smith. That, at least in that instance, which I know is similar to the one in count 1, would be a non-technical. If you're found to be guilty of a non-technical, the court could or would not be limited to that sliding scale. It would only be limited by the amount allowed under the law. However, the people have agreed to dismiss count 3. Is that what you understood you would be doing today, sir?
Yes, sir.
By pleading guilty, you'll not have a formal hearing and you'll be waiving certain rights, which include the right to have a formal hearing. That is not a trial, but it is in front of the court. At that formal hearing, the prosecutor have the burden of proof by a preponderance of the evidence. At that hearing, you can, of course, be represented by your appointed counsel. You'd also have the right to question, cross-examine any witnesses presented against you, as well as to present witnesses, evidence, or testimony, and the right to remain silent, as well as the right to not have silence used against you. You understand?
Yes, sir.
As to counts, I'm sorry, has anyone made any of their promises, threats, or inducements besides the dismissal of the third count to get you to plead guilty to the first two?
No, sir.
Therefore, as to counts 1 and 2, how do you plead?
Guilty.
The court must have you tell me what it is that you did that makes you guilty of that offense. Before you do, however, I hereby take judicial notice of the terms and conditions of probation that were issued in this file and signed by me on December 17th of 2024 and were subsequently acknowledged by you on, well, it looks like it says December 17th, the same date. Anyways, after that, why don't you go ahead and tell me what happened on September 25th? Is it true that you had some kind of assaultive behavior upon Chelsea Aarons Smith?
Yes, sir.
And what was it that you did that was assaultive, abusive, threatening, or intimidating?
I threw a Bic lighter at her, hitting her in her shoulder.
Okay. And were you in a domestic relationship with Miss Smith still? I know I've heard her name before.
Yes, sir.
All right. And would you agree that that was assaultive, abusive, threatening, or intimidating by some degree?
Absolutely, sir.
Is it also true that on or about the 24th of September this year, you had used a controlled substance, methamphetamine?
Yeah. Yes, sir.
Mr. Ziegler, do you believe the defendant provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with, in this particular case, 6.445?
Yes, Your Honor.
And Mr. Niegos, do you agree with all three?
I do, Judge. Thank you.
The court finds the defendant's plea is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record, in addition to the judicial notice of the terms and conditions, satisfy the elements for the 2 probation violations. Therefore, the defendant is found guilty of counts 1 and 2. Count 3 is hereby dismissed. I assume we can proceed to sentencing, Mr. Stapleton.
Yes, Your Honor.
Any objection to doing that, Mr. Ziegler?
No, Your Honor.
Any objection to that, Mr. Niegos?
No, Judge.
Mr. Failer, you have the right to be physically present in the courtroom when the court issues a sentence. However, if you are willing to allow us to waive that right now, I can do the sentence now. Waive that
Yeah,
right?
I can waive that, sir.
All right, thank you.
Sorry.
The court, that's okay. The court finds that the technology is appropriate and we are able to proceed underneath the court rules. All right, let's go ahead and start off with Mr. Stapleton. Do you know how much time he's serving on that domestic violence, by the way?
He served 20 days credit,
Okay, thank you.
time served.
So what kind of, what credit does he have here for us now?
He has 164 days. He has 29 days since 9/25.
So, but does the 164 include that?
Yes, that does include that.
Thank you.
Yep. So there's actually 29 days. So essentially time served. Mr. Failer is never going to get it. He keeps coming back to Cadillac where he continuously violates the, to his credit, he actually had moved away for a while and he was doing well until he came back. I recommend probation be revoked. You're at 30 days, basically an additional 30 days jail on top of, we can't do any more than basically his time served. And fines and costs preserved.
All right, thank you very much. Mr. Ziegler, anything further to add, sir?
I would agree with probation and parole, Your Honor. I'd ask the court to adopt those same recommendations.
Any further, Mr. Niegos?
Judge, I do want my client to hear me say this on his behalf. I'm a little disappointed to hear Mr. Stapleton's use those. This is an individual that had 16 months of sobriety, and when I come in contact with these folks, yes, of course they're aware of technical versus non-technical, the potential ramifications, but ultimately, and onto the new case, there really was no discussion about minimizing what he did. There was no discussion about, she might not show up, I might do this or that, which again, as the court knows, sometimes in these cases happens. He really did want to take responsibility, and without disclosing significant attorney-client stuff, he was really, really, really disappointed in himself because he said, this is about as long as I've had it together. So I think I want him to know that, at least for what it's worth, I think he can do it. He has done it. He's proven to himself he can do it. I know he's got a family member that's been reaching out to me, and Mr. Feller wanted me to thank your court staff for finding the spot, and to you, Judge, to have this hearing moved up to today. His father's in some dire medical conditions, and like I told Judge Wiggins, I sometimes, unfortunately, in this position, you get a little cynical, you get a little calloused, and you can kind of tell when people say things that they know they should be saying, or every now and then you're struck differently. And so far, in my experience through Friday, October 24 with Dustin, he's been the latter. I hope I'm not proven wrong. I obviously have in the past, unfortunately, but I hope in this case he continues to go back to how he was prior to falling off the horse and relapsing, and understand that he's got these people in the community that really still stand by him, and he's fortunate to have that. So I would ask the court otherwise to follow the recommendations. Thank you, Judge.
Mr. Failer, is there anything else you wish to add at this time, sir?
Yeah, I'm just gonna make it real quick, sir. I remember when you sentenced me back in December on this, and you gave me the opportunity to go to rehab and change my life, and I did. I remember you telling me like you've had 2 or 3 people wanted to come back, or you've had to come back and say that they successfully, got it. And I wanted to be that 4th, and I still want to be that 4th. I respect everything that was said about me. Deserving, I've been struggling with drugs and alcohol for 20 plus years. We all know this. I made a horrible decision 2 days prior to that. I ruined 16 months of sobriety. I did come back to Cadillac. It wasn't just because I wanted to come back to Cadillac. It was a bad choice, but I had a lot of family issues going on in Traverse City. Just the means of living there is really, really hard. And I just made 2 poor choices, and I still am going to be that number 4th and number 5th guy that gets to tell you in a few years, hey, look, I got it. That's all I got.
Okay, Mr. Stapleton, did I see it correct? The last sentence was 135 days.
That you are correct.
All right, thank you. Dustin, I see you. I know Mr. Nagos and Mr. Ziegler. They're the 2 that are rookies on this particular case, and that's okay. I see you. I generally see you as being a guy who comes across someone as genuine, but then when it gets out, continues to make some bad choices. However, I do recognize that you had that period of sobriety, and I hope that it's legitimate. And you did some treatment. Mr. Stapleton, did he do a treatment program?
He did do a treatment program. He was in the treatment program when he was sentenced. And
Yeah.
He was in a sobriety house.
Yeah, I was going to ask, did he complete the 90-day sobriety?
He did.
program? Great.
Yep.
Great. Dustin, I'm glad to see that you completed sobriety program, the sober living house. You did the treatment, and I'm very glad for that. I hope that you continue on moving in the right direction. The question that I'm having right now is whether or not to keep you on probation. The court preserves any fines and costs. The court sentences the defendant to 165 days to 164 days of credit. Presumably you've kept all your good conduct time, so you'll be released today. The question is whether or not I keep you on probation. Mr. Stapleton, I know that there's that argument about he just doesn't get it, because I know we see him often enough. I would say if I call a case and I can remember the person's middle name, that's generally not a good thing. I don't know the middle name of most of my best friends. That's not picking at you, Dustin, because you've generally been pretty upfront. Right now, you're going to get out, but my question is do I leave them in probation? Mr. Failer, what do you think?
Sir, I would love to say, take me off it, but I'm going to be honest with you. I think it would be good for me to be on it. I know I could stop. I could just tell you right now, like, I don't want to be on it. I could walk out today and not be on it, but I honestly believe it's a good thing for me to be on. I was truly following all the rules of it until a couple of days prior to this incident.
Mr. Stapleton, besides his back history, which I can't detail it, I know enough of it. Besides this issue, how else has he been doing on his probation?
He's done fine, as a matter of fact.
Yeah, okay. All right. Dustin, the court's going to continue your period of probation with the same terms and conditions that were previously set. I hope that you continue to do well. I hope that you are continuing to seek out some treatment. If you need any, all you've got to do is ask Mr. Stapleton, whether it's Catholic Human Services, addiction treatment services up in Traverse, whatever we can help get you involved in within the budgets and money that we have, which of course is limited. I really, I want you to succeed. So, all right, you'll receive through Mr. Stapleton most likely 2 copies of one document. You've already done this before. You'll place your initials on one, keep the other. This document will tell you that you have the right to appeal the conviction and sentence in your case, which is done by filing an application for leave to appeal based upon the original pleas here in this case. Any application, I'm sorry, if you choose to file an application for leave and you want the court to appoint an attorney to assist you, you may complete the bottom half of one of those copies and return it back to the court within 42 days. Do you understand, Mr. Failer?
Yes, sir.
So I sometimes go back and forth, so I call you Dustin only to let you know, and whether or not you're doing well, whether or not you're fudging me a bit, I still really hope for the best for you, and I hope that you continue to do, I hope you go back to doing well and staying off the drugs, because if you're not, because when you're on them, as we can see here, and I remember the last case, stupid stuff. Right? So anyways, get the help that you need. Anything further, Mr. Stapleton?
No, Your Honor.
And I do respect and appreciate Mr. Stapleton's opinion. It's always important that a probation officer and a prosecutor and everybody speaks honestly and freely, because that's what they're supposed to do. But I'm going to give this section another chance. Anything further, Mr. Ziegler?
No, Your Honor.
Anything further, Mr. Niegos?
No, Your Honor. Thank you.
Thank you. We're adjourned.
Okie dokie, friends. Let's we're getting into hangry time. Let's go check in on Judge Glazer real quick as they approach lunch.
19 years.
Huh?
19 years, ma'am.
I don't know what's from, Jim, I don't mind house arrest. Would you do pre-trial? I mean, not house, it's pre-trial, I'm okay with that. You have money to post the bond?
Yes.
You want me to set a bond or you want pre-trial?
Set bond.
I'll set his bond at $3,000. Have a nice day. Next case is Adelson Ortega, page 9. Is he here today? Or it's reset for private attorney? We reset this every day. And is the interpreter? Come on down, sir. Mr. Ortega. So did you hire a lawyer? He's a Spanish.
¿Pudo contratar abogado, señor Ortega? ¿Sí o no?
Sí, creo que sí, es Richard López.
Yes, I think so. His name is Richard Lopez.
Is there a lawyer here for Mr. Ortega? Because I don't see one.
Hay un abogado presente aquí para el señor Ortega porque no veo a nadie.
So this is now the second reset. There's no lawyer. The lawyer needs to come to court.
Ya esta es la segunda vez. El abogado tiene que estar presente, tiene que presentarse a la corte para representarlo.
Do you know why the lawyer's not in court today?
¿Sabe usted por qué el abogado no está presente hoy? ¿Sabes por qué?
I only know his name and last name. That's it.
¿Qué? I didn't hear him.
Que solamente sé su nombre y apellido, ya no sé más
I
nada.
just know his name.
What is the name?
Richard Lopez.
Richard Lopez.
Lopez? Okay. I don't, the only ones I see here are the Richard Lopez, who practices international law, and another one in a different county. You
Sí,
sure
el
that's
único,
clear?
Richard López es un abogado internacional y el otro solamente ejerce y está en otro condado.
I'll set your case in the afternoon. Tell your
Voy a-
lawyer to come to court, and if he's not here, I'm going to set a bond.
Mira, dígale a su abogado, llámelo y dígale que tiene que presentarse a la corte en la tarde. Vamos a fijarlo para esta tarde, ¿está bien? Si él no se presenta, entonces voy a fijar una fianza en su caso,
But at one
¿entendido?
more time, the third,
Voy a fijar
let me
una
see.
vez más en la tarde, lo vamos a fijar.
Actually, this is the third reset, isn't it? No, you saw him on yesterday morning. Too. I'll set it one more time in the afternoon. If he's not here, I'm going to set a bond.
Está bien, lo voy a fijar en la tarde. Si no se presenta, voy a fijar una fianza a favor suyo, ¿ok?
Thank you.
Gracias, puede tomar asiento.
Stay orders in here or let me somewhere else because I've read stay orders already.
Well, we've seen worse out of Glazer as she approaches lunchtime. Good morning once again, everybody. I think there's some new people out there, so welcome to the Courtroom Files Live. It's good to have you with us. If you have stumbled in here for the first time, you've stumbled into one of the best communities in LawTube. This is a good base of people out here, so feel free to interact with them in the chat. You'll like it here, trust me. Let's go back to Judge Anzalone, Lenawee County. And, well, as soon as I hit the right button anyways, I think she's got another sentencing.
Thank you. This is in the matter of the people of the state of Michigan versus Adam Christopher Steers, file number 25-22236F8. I have Brian Fry appearing on behalf of Mr. Steers, and I have Ashley Messer appearing on behalf of the Attorney General's office. Says the date and time set for sentencing in this matter. Mr. Steers, have you had an opportunity to read and review the pre-sentence report?
Yes.
Have you had an opportunity to discuss that with your attorney?
Yes, Your Honor.
Are you satisfied with your attorney and the advice that she has given you?
Yes.
He has given you. I'm sorry. Jen Walsh is, Ms. Teskey, are you here for Ms. Walsh? Sarah Teskey?
Judge, I'm here covering Jen on this case.
Okay, thank you. All right. So, Mr. Fry, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, not at the time that it was made, Your Honor. We would note that this pre-sentence report was made when my client was still incarcerated at Hillsdale County Jail. He's since been released and is employed now and paying his child support now. So, but obviously that information wasn't known to the probation officer at the time.
Okay. Ms. Messer, do you wish to explain or challenge the accuracy or relevancy of any information in the report with the update that he's no longer incarcerated, he's employed, and allegedly is making payments on his child support?
No, Your Honor, thank you.
Okay, and do you have verification that payments are being made at this time?
Your Honor, I don't see that payments are being made to this file. This is an arrearage only file, and I can check and see if Mr. Steers does have other files. Perhaps if he's making payments, it's just going to those. Let me see. He does have 2 files, and both of them do have arrearages. It looks like there was a payment made 10/22/25, but it went to a different file, not to Miss Taphouse's case where she's a victim. So he did make a payment. It just didn't get applied to this case.
Okay, so here's the problem. Because you have active files, anything they're withholding from your paycheck is going to go to those active files. And you live here in Lenawee County, correct?
Yes.
All right, so my advice to you is you're gonna have to pay extra out of pocket on this file here in person.
Okay.
Okay, because you're gonna have to direct the payment because this is arrearages only.
Okay.
Do you understand? Please get close to the mic, sir. Yeah. Okay, so thank you, Ms. Messer. And, all right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect, Mr. Fry?
I don't believe so, Your Honor.
All right, Ms. Messer?
No, Your Honor, thank you.
Probation Department in this case has computed the minimum sentencing guidelines to be 2 to 17 months. Do you agree with that computation of guidelines, Mr. Fry?
So, Your Honor, obviously I was not Mr. Steers' attorney when he did his plea. There was a conflict with public defenders and I just took this over for this hearing. But when I reviewed the guidelines, we do have a couple of disagreements. with the scoring.
Okay, hold on.
OB 16.
Slow down.
Sorry.
Let me get to the page. All right, so OB 16, property obtained, damaged, lost, or destroyed. So let me get there. So Ms. Walsh scored OB 16 at 5 points. The property had a value of $1,000 or more, but not more than $20,000. So I'm gonna guess your argument is because this is child support, it's not deemed property.
Correct, Your Honor.
All right, Ms. Messer.
Stipulate to that being 0, Your Honor.
Okay, so we will strike OB 16 as 0. So that will take his OBs to 0. And does that change his grid?
No, Your Honor.
Okay.
Change the grid, but.
Any PRVs that you wish to dispute?
PRV 7, Your Honor, which is concurrent convictions. He did have 2 counts in this case, but count 1 was dismissed. So he only was actually convicted of 1 count. So there was no.
Count 2 added for purposes of a plea?
No, Your Honor, I think he was always charged with 2 counts of failing to pay child support, and the plea agreement, as far as I'm aware, was count 2, count 1 was dismissed. So he was only convicted of that 1 count, which is a sentencing offense. There was no concurrent conviction. So we believe that that should also be scored at 0, and it's scored at 10.
Spencer?
Your Honor, I agree. The defendant pled guilty to count 1 and count 2 was dismissed. Perhaps this was just calculated as charged, but yes, he did only was convicted of 1 count. So OB 7 should be 0, or PRV 7 should be 0.
Okay.
And I believe that changes the guidelines to 0 to 9 months, Your Honor.
Okay.
So, Your Honor, I'm changing PRV what?
PRV 7 will be 0.
Okay.
And OB 16 will be 0.
Okay.
That makes the guidelines 20 over 0, and 0 to 9 months for guideline minimum range.
Okay.
All right, so we have made those changes. Mr. Fry, anything else with the guidelines?
Nothing further with the guidelines.
All right, anything else with the guidelines, Ms. Messer?
No, Your Honor, thank you.
Ms. Messer, is there anything you'd like to say on behalf of the Attorney General's office before the court?
Your Honor, if I could just, I'm sorry, Your Honor, I didn't mean to cut you off. If I could just inquire whether or not Ms. Taphouse is in the courtroom or on Zoom. She is the victim in this case.
Not in the courtroom, and she's not on Zoom.
Thank you so much, Your Honor. Your Honor, at this point, the defendant owes $29,738.22. As we've discussed with him, he hasn't made payments on this file in quite some time. It is an arrearage only case. He does have another active file, and as Your Honor already stated, he did make a recent payment. However, because that other case is charging, it went to that case. So I would just ask that he be placed on a term of probation so we can monitor his payments on this file, as there is quite a high arrearage. Thank you.
Mr. Fry?
Yes, Your Honor, we would ask that the court place my client on probation, monitor his payments. As we've discussed, he was incarcerated on this case. He did get a PR bond and then was immediately picked up by Hillsdale and was incarcerated there until September 22nd. So he's been out a month or so. Since he's gotten out, he is employed with Maxable. He did bring me a couple of his pay stubs here this morning, and they have been taking money out for child support. You know, as he found out this morning, it's not being applied to this case apparently, but that's something that he can address going forward now that he knows, you know, that's being applied to a different case. But he is employed now. He is making child support payments in some cases, apparently a different case, but he can make an extra payment as the court indicated on this case now that he's aware. You know, but again, he is gainfully employed now, and you know, he is making child support payments, and he's prepared to continue to do that. Thank you.
Okay. Anything you want to say on your own behalf?
No, Your Honor.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law, and protection of society. It's sentenced to the court and be placed on probation for a period of 3 years. During that term of probation, you will obey and comply with all the articles and provisions in your probation terms. So how many hours a week are you working?
40.
40, and how much you make an hour?
14.
14 an hour. All right, I'm gonna waive the 750 in court costs. I'm gonna order a $130 crime victim rights fee, $68 in state costs, $30 per month supervision fee, 60 if we have to put a tether on you. Okay, I don't want to do that. So your restitution obviously is your arrearage. You would have to make a payment of like $820 a month to pay this off during the 3 years. Based on your income, the fact you have a currently charging case, I recognize that that's not going to happen. You understand?
Yes,
But I have had people pay it off. They, fix up cars and sell them. Like they do stuff. So, we're going to want to see a monthly payment made on this. And I know it's gonna be tough if you're paying that case and you're making 14 bucks an hour, but as long as you're paying something every month, like 100 bucks, 200 bucks or more when you can, that obviously will show that you're paying your other child support case and paying this, and that's a good faith effort. Let's see, you have 83 days jail credit. During your term of probation, why not? Let me see. License suspended. All right, so I'm not going to order alcohol terms because I don't have any indication in there that you have an alcohol issue. Just don't be stupid, right? Okay. No use of illegal controlled substances, obviously, because that's illegal. Complete any treatment as required. Report truthfully as often as required. Are you living in Hillsdale?
No.
No, yeah, that's right. You live here. Report as often as required, obey all court orders, not to engage in the assaultive, abusive, threatening, or intimidating behavior. Let's see. You can't possess a weapon. Understand that they can come in your house at any time to verify you live there. And then if they believe you have items which could violate their terms of probation, they have the right to search your house, your car, your phone and things of that nature. Be truthful with them about police contact or job loss or moving, maintain employment. There's a $60 DNA fee too as well. Ms. Teskey, anything else? Do you want him to report Tuesday morning?
I would like him to report to Mr. Stevenson on November 4th at 8 a.m.
Mr. Stevenson's going to be his PO?
Yes.
All right, and that's November 4, you said?
Yes.
So 2 weeks from, so not next Tuesday, but the following Tuesday?
Yeah, I report to Mr. Stevenson every second Tuesday of the month.
You know what?
Well, this is
call him
right now.
Yeah. So do you report next week?
Yep.
All right. When you report, just talk to Mike about it. You guys will figure it out. He'll put you on the same schedule.
Okay.
All right. Anything else, Miss Messer?
No, Your Honor, thank you so much.
All right. Thank you. All right. Good luck, sir. Thank you.
you.
Oh, wait, you got to sign your appellate rights.
Mr. Fine, Mr. Van approach just for a minute.
Yeah. So you do have a right to appeal the sentence. So my bailiff's going to hand down to your notice of right to appellate review. You got me nervous. You were congregating. So you're going to initial and date one copy for our records. If you want to appeal my sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, Ms. Messer, thank you. I'm going to pop the courtroom in the waiting room.
Thank you. Have a good day.
Thank you.
Thank you, Your Honor. Thank you.
So, friends, I want to show you something cool, and I'm kind of having to jury rig it just a little bit because, again, the interwebs are just plain broken, and unfortunately, I can't get it to display properly from her website. But I did want to call out a special sponsor for today's show, and that is Thumper's Crafts, which, Barbara, if you'd be so kind as to drop the link for that, please. So Thumper's Crafts is a pet treat and toy and food type of shop that is run by a young teen that my wife and I have been kind of mentoring for a couple of years now. And she does great work. And what you're seeing on the screen right now is 4 photos she sent from what will be part of her Christmas launch, which apparently is going to happen somewhere around the 8th of next month. If she does what she's done before, the stockings will be personalized, but you see some treats in the top left. You see some rabbit treats in the bottom right. Up on the top right, those are cat toys that are filled with real catnip that our cats just absolutely love. She does really good work, very motivated young lady, and I encourage you to check her out. So, Barbara, again, thank you. You put the link in the chat to her Etsy shop. And you can use code TCF12, TCF12, and you can get 12% off of your order. And that is good on anything in her shop, and you can use it right now, or you can wait until her Christmas launch, which, again, I think will be around the 8th of November, so a couple weeks away yet. But please do check her out. Again, the Thumper's Crafts link is in the chat, and you can use code TCF12, TCF12 to get 12% off, and that code is active now. So thanks for supporting her. We encourage young people who really work hard here. So please do give her your patronage, or at least consider doing so. Let's go to Georgia, Clayton County. Normally we do a hallway court there, but it looks like they're doing a bond hearing. So let's see what that's all about.
This is the bond hearing of Donnie Smith, charged in warrant number 2025 CW 56800, vehicular homicide. Only one charge on the bond calendar. He's also charged in 2025 CW 56796, reckless driving. 2025 CW 56797, public officer violation of his oath. 2025 CW 56798, failure to make a report. And 2025 CW 56799, hit and run. Representing the state is ADA Thomas. Representing the defendant is Attorney Devin Rapus. This is your motion, Attorney Rapus. And Deputy, if you would mute, please. All right, thank you.
Thank you, Your Honor.
Excuse me, Mr. Rapus. I don't think the jail is muted. Judge, do you see the jail is being muted?
I do not.
Okay, there they are. I muted them.
Thank you, Judge. So for purposes of the bond, I believe we're just being heard for the vehicular homicide, since he has bond on the other counts, if I'm not mistaken. It should just be the vehicular homicide that he doesn't have bond on.
Right. I can consider all the counts, though.
Understood. I just wanted to make sure.
Right.
So for purposes of today, I know we all understand the IOLA factors, but sometimes I just like to give like a little refresher course, if you will. So for purposes of today, I'm going to address the no significant risk of fleeing or flight, no significant risk of danger to the community or to any persons, no significant risk of committing any felonies pending trial if the court were to grant him bond, and no significant risk of intimidating any witnesses. It's obviously my burden of production. I'll meet that burden through establishing his length and character in the community, his employment status before his arrest, responding to any sort of legal process. He hasn't had any, and I'll get into that, and any prior criminal record, which he has none. The purpose of pretrial bond is to prevent punishment before conviction and to secure the appearance of the person in court for trial. Obviously, that's the main purpose, is to make sure he's going to show back up for court when he has court. The most fundamental premise in our system is that a person not ought to be punished for a criminal offense until the state demonstrates guilt beyond a reasonable doubt. And so with that being said, one of the factors is not, was he caught red-handed or anything like that, is significant risk of flight, danger, committing a felony, or intimidating witnesses. So Mr. Smith is currently 47 years old. He's lived in Georgia his entire life. He has a house and has been there for the past 24 years in College Park. He's lived in Fulton County specifically a majority of his life, but has been living at that house that he has for the past 24 years. He does have family. He has dads, sisters, brothers, uncles, cousins, and almost all of them live in Georgia. His mom, unfortunately, has passed away. His dad and the rest of his family are watching on the live stream and have been very involved and been speaking with me quite frequently about the case and getting updates on Mr. Smith's status. He does have education. He graduated from high school, Alonzo High in Atlanta, and then went to Stillman College in Alabama, where he got, I believe it's the associate's degree for the 2-year program. As Your Honor may remember from the prelim hearing we had on Wednesday, he was with the he was with the College Park Police Department for the past 14 years, where he was moved his way up to the ranks, and at the time of the incident was a sergeant, was actually about to be promoted to lieutenant at the time. So he'd been with that police department for 14 years. Before that, he was a jailer at Fulton County Jail for about 5 years, starting in 2001. So he's been in law enforcement he's essentially established it as his career and has been doing that for quite a while. I did submit some character letters to the court and provided that via email to the court and to the state. I'd just like to reference some highlights in those letters, because a lot of those letters do come from people that were working with him or know him in some capacity. And so Dr. Dwight Baker, in his character letter, said that he's had the privilege of working with Mr. Smith during his tenure as Director of Human Resources and Risk Management with the City of College Park on 3 different occasions. He was well regarded, calm demeanor, cooperative attitude, and his ability to handle challenging circumstances with professionalism and grace. He says, while the current situation is undoubtedly serious and tragic, I respectfully ask the court to consider the totality of Mr. Smith's character and service. I have known Mr. Smith, and he's not defined by this incident alone, but by decades of honorable work, respect for others, and dedication to his community. We have Mr. Robert C. Grady. He's a chief deputy. He says, while Donnie has faced a recent challenge, I believe it's important to recognize that a single moment doesn't define an entire person's character or career. He said that as a law enforcement administrator, he's witnessed firsthand Donnie's professionalism, integrity, and commitment to doing what's right. He says, I stand behind him with confidence, knowing that his future contributions will continue to be grounded in the lessons he has learned and the strong moral foundation he has always possessed. Jean Robinson goes on to say that Donnie Smith is one of the kindest, most thoughtful people that she knows. I believe this is a lieutenant. I could get the title wrong, but H. Dorsey says that he's known Mr. Smith since he began his law enforcement career with the City of College Park Police Department back in 2011. Mr. Dorsey was his field training officer and had the privilege of mentoring Mr. Smith during his early months in the profession. Over the years, Donnie's professional growth has been evident through his service in multiple divisions and his promotion to the rank of sergeant. I'm aware of the charges that Donnie was arrested for, but it's important to recognize that this incident does not define the totality of his character or service. He's deeply devoted to his family and consistently strives to be a positive influence.
Attorney Rapus, I'm sorry. I got booted off for a second. I was on your second character letter.
I'm sorry, Judge. The second one I was just referencing was a Robert C. Grady that the court has, and it just says that Donnie's faced a recent challenge and made a mistake. I believe it's important to recognize that a single moment does not define a person's entire character or entire career, that he's witnessed firsthand Donnie's professionalism, integrity, and commitment to doing what's right. He stands behind him with confidence, knowing that his future contributions will continue to be grounded in the lessons he's learned and the moral foundation he's always possessed. Next character letter is Jean Robinson. It says that Donnie Smith is one of the kindest and most thoughtful people that she knows. Next character letter is from Mr. Dorsey, and I believe his title is lieutenant, but I could be wrong. But he says that he's known Donnie Smith since he began his law enforcement career with the College Park Police Department in 2011. Mr. Dorsey was actually the field training officer for Mr. Smith and had the privilege of mentoring him during his early months in the profession. Over the years, Donnie's professional growth has been evident through his service in multiple divisions and his promotion to the rank of sergeant. He's aware of the charges that Donnie was arrested for, but again, like the other character letters, he says it's important to recognize that this incident does not define the totality of his character or service, and that he's deeply devoted to his family and continues to be a positive influence on those around him. We have a next character letters from a Colonel David Block. He's retired colonel from College Park Police Department. He says that he continues to serve part-time with College Park Police Department currently, and that he served on the hiring board that recommended Donnie for employment over 14 years ago. He says it's a decision that I've never once regretted. He says that he could speak at length about Donnie, but he's the kind of officer he would hope would respond to if he needed anything of assistance. And he said that I ask, again, like the other character letters, I ask that you consider the totality of Sergeant Smith's career. He is not a flight risk and deserves the opportunity to post a reasonable bail so he may return home and properly prepare a meaningful defense. And then finally, Judge, the last one I'll reference is from a Tiffany Thomas. She's a deputy sheriff at Fulton County Sheriff's Office. She's known him for 10 years during his service with College Park Police Department. During his time under her supervision there, Sergeant Smith distinguished himself as a reliable and hardworking professional who took pride in his role and the responsibilities entrusted to him. He displayed exceptional leadership, mentoring junior staff and managing complex situations with sound judgment. He's a dedicated individual who's made meaningful contributions throughout his career. And again, like most of the other ones say, it's important to recognize that this single event does not define his career or his character. Just a few character letters. I told the family not to bombard me with many, but I'm sure we could have gotten many more. I've said that most of them would probably be redundant after about 5 or 6. But Judge, based on those character letters, based on the facts that I've proffered to the court with regards to Mr. Smith's history in Georgia, no prior convictions, no prior arrests, 47 years old, went his entire life serving in law enforcement, serving the community. Up until this point, we have his first arrest. And again, this is based, as you remember from the prelim, based on a, I guess, taking the state's theory as true and the evidence presented as true, as a policy violation for a pursuit. And then the car crashed, and that's what led to the 2 deaths. It was a quarter mile about in front of Mr. Smith's patrol vehicle based on the testimony from the prelim. Based on the evidence that we have today and things that I've said, he's not a significant risk of flight. We know that. He has ties to the community here. He's got his family. He has his house that he's been here. He's served in law enforcement here for years. He poses no significant risk of threat or danger to any person or the community. I'm not sure. I would imagine the state's argument might just be that factor, that it's just a danger to the community. My position would be this happened during his role as a law enforcement officer. He's obviously not working in that capacity anymore, nor can he work in any capacity as a law enforcement officer. I doubt the state's going to say that as a civilian, they expect for him to conduct high-speed pursuits of individuals with stolen vehicles. He poses no significant risk of committing any felony. These are no facts that would suggest that he's going to commit any other crimes due to the lack of history his entire life. And then, of course, no significant risk of intimidating witnesses. There are no witnesses in this case to intimidate. And so what I'm asking for, Judge, for the vehicular homicide charge, I'm asking for a $15,000 bond. Obviously, if the court wants to put that he cannot work in any sort of law enforcement capacity, that's fine. He can't do it anyway with the current charges. And that's I think that's what I'd ask for. I don't know if any other special conditions are necessary. I do know that he needs to get back to work, obviously not in a law enforcement capacity, to continue to pay his mortgage that he's had for the past 24 years. And so I'm asking for a $15,000 bond, Judge. And if the court has any questions, I'm happy to answer it.
Ready? ADA Thomas?
Your Honor, as a law enforcement officer, when this happened, this defendant was held to a higher standard by the community as a whole and his agency in particular. He was acting in a marked patrol vehicle, uniformed, when this incident happened. This wasn't an accident. And to say that it was bad judgment would probably be an understatement to the maximum. 2 things that defense counsel said that kind of stuck with me, and I made a point to write them down. One of them was a mention that a single moment or a single act does not define your character. But I would contend that a single moment, a single act can truly expose you for what you really are. Maybe it does, that single time, show the world what's really going on. This man violated his oath of office, but for his behavior, it could be argued that 2 people would still be with us on this earth. He was entrusted with the community's, he was entrusted by the community to safeguard their property, to safeguard our streets, to safeguard our lives. In this particular situation, not only was he the precipitating factor for the accident itself, but he didn't even bother to call just to get these people some help. He didn't even bother to file a report to indicate that something happened. And this is based on the testimony of the trooper, which the court heard on Wednesday. He didn't even bother to let someone know, even make an anonymous call, to let somebody know that car had, in fact, wrecked. And then he went through the extra step to try to conceal the video that was recorded as a result of the unauthorized chase. Does a person's character manifest in one act? Based on the trooper's testimony, perhaps it did. And based on what we now know of former Officer Smith's behavior, state would contend that he is a significant threat or danger to the community. That he is a significant risk of perhaps committing an additional felony in the future. Defense counsel mentioned one more thing that is kind of, I thought about it myself, but he actually brought it up. There is no witnesses to intimidate. That is the 5th Ayala factor, Your Honor. He's absolutely right. There are no witnesses because those witnesses were involved in an accident as a result of his behavior and were left to die on the side of that road. So yeah, he's absolutely correct. There are none. But that officer's patrol car, which told on him because it recorded the whole thing. To the point where, as I mentioned previously, he attempted to conceal that video. But the trooper saw it. And as the court may recall, the trooper indicated upon watching that video, he noted that you can't hear anyone talking, but at the end, after the accident, you can hear somebody laughing. What does that say about this man's character? You just watched somebody have what turned out to be a fatal accident where 2 people died, and you're laughing. You know, and I would contend again, he is a risk to the safety of the community. He is a risk of committing possibly an additional felony. State would be asking for no bond in this matter.
All right. So I have a couple of questions. And so, ADA Thomas, you can see that there is no prior criminal history?
Yes, ma'am. He was a sworn officer at the time of this incident.
And the date of this incident, what was the date of this incident?
August 17, Judge.
August?
That's correct. Yes, Your Honor.
And how long has he been in custody?
Not since that date, Your Honor, because investigation.
September 23rd, Judge, based on the jail records.
Yeah, and I'm pulling the booking sheet. I believe that's correct, Your Honor.
September 23rd?
Yes, ma'am.
And so, counsel, did you indicate that, I'm sure prior to being arrested, would he have employment? He probably does not have employment at this time?
Not right now. I think that he'll be able to obviously apply to other jobs and things of that nature. But not right now. Since the arrest, he's obviously not been employed because he was with that police department for so long. And so he would have to find new employment.
Your Honor, if the court recalls, I believe the trooper mentioned that during the course of this investigation, he found out that apparently that Mr. Smith had applied for employment somewhere at another agency.
Okay.
So the trooper took that to mean that he was no longer with College Park, but the actual termination, he did not know.
Alrighty, and did Mr. Smith turn himself in, or did they go get him? How did he come into custody?
Yeah, Judge, they didn't, surprisingly, they didn't call him or sort of let him know, as being a law enforcement officer for so long, he would have turned himself in. They actually came to get him. He had no idea about the arrest warrant or anything. But everything else, I think, sorry, go ahead, Judge.
This case is troubling.
Your Honor, if I may, regarding him turning himself in, that's my understanding of that is generally what happens. But the impression I got from the trooper is that they were so concerned with him actually concealing that video and absolutely not mentioning anything about this. And that might explain why they actually decided to go get him.
Well, I don't know if Your Honor's waiting for me to respond to that. We can speculate. I think Mr. Smith would have turned himself in if they would have just called him. I think he was very upset when I spoke with him that they did it like that, because it caught him off guard. He had no idea about the arrest warrant. As far as the video, the testimony was that all he knows is that the major said that it took him a while to find it, as if it were meant to conceal it. We don't know any other information. I wish we could have found out more about that, but we'll obviously get that information at the trial phase with discovery, which a lot of this stuff was like closing arguments for the trial, but as for purposes of Ayala, I believe everything's met.
All right, and so as counsel indicated, I must consider the Ayala factors. Whether Mr. Smith poses a significant risk of fleeing and not appearing, there's nothing to suggest that. Whether he is a threat or danger to any person or community or property at this time. I don't have any testimony or evidence that he would pose a threat to the community. Obviously, he's not in law enforcement anymore. So that alleviates that. Pose no significant risk of committing any felonies while pending trial. And so I can't imagine that's not an issue based on his criminal history, and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. Being the fact that he doesn't work there anymore, I'm not sure how that could be possible as well. I did not hear any specifics about his financial resources other than he's not employed. I don't know if he have any other sources of income. I do have to take that into consideration.
Judge, I don't really have information as far as his financials. I wouldn't be able to give the court at this time, unless you'd like to hear from Mr. Smith. I have no problem with him explaining to the court his financial position with regards to that aspect only. In order to determine a reasonable bond, I have no problem with that.
If you can just ask Mr. Smith, was his employment was the only source of income?
Ms. Smith, you want to answer that question, but I think they have to unmute you first.
Jail. Jail, are y'all able to unmute?
It's unmuted now, ma'am.
Thank you.
Can you hear me?
Yes.
Okay.
I said no, I'm currently not employed.
Mr. Rafus,
Yes.
ask your question.
Yeah, go ahead, Mr. Smith. You can tell the judge about what financial sources of income that you have, and if College Park Police Department was that your only source of income?
Yes, at the time it was my only source of income, but I do have ways of, to get, income, and I also do have money set to the side to pay bills for a few.
How much money do you have set aside? How much do you have in your account?
Few $1,000.
Okay.
All right. So again, this is a troubling case as we have two individuals that are deceased based upon some actions that are alleged in these warrants. But I have to go back to the purpose of a bond is number one, to ensure that the defendant appears in court to answer to the charges and to protect the public. So for public safety reasons, if that person is released from jail while they are pending, while the case is pending. I see, I think that the allegations are troubling, to say the least. But I think that I am obligated to set a bond in this case based upon the IOLA factors. The issue is going to be the amount. And the conditions that I impose. Of course, the defense has already agreed that Mr. Smith will not and cannot apply or work for any law enforcement agency in any law enforcement capacity at all. We know that. And I'm not sure, other than some sort of home confinement, other than work, church, and court, what other conditions could be imposed. And so I do want some language in the bond where if Mr. Smith is able to make, or when Mr. Smith is able to make bond, he is to remain in the confinements of his home unless he is going to work. Doctor appointments, court. Mr. Smith, if at any point you are stopped by police, if you have any contact with law enforcement, if law enforcement gets information that you are not inside your home and not doing one of the things that I've indicated, then you could be rearrested and placed back in jail. You understand that?
Yes, Your Honor.
88 Thomas, are there before I provide the bond amount, are there any other conditions that you would want to see on this bond order?
I'd like for him not to be driving, no driving, Your Honor.
How will he get to work?
Unless for the purposes that the court just outlined.
I don't know if we can. I think the staying at home encompasses that, because he shouldn't be, if he's not going to work, he shouldn't be out anyway, so he wouldn't be out driving. So I think we got that covered under he may only leave the residence. And so I don't want to put his address on YouTube, but when you compose that, Attorney Rafus, I would like to have that information in there. And also, without saying names, does he reside alone or does he reside with a family?
Alone, Your Honor.
I'm sorry?
Alone?
Okay, nobody else resides in the home.
No.
All right. This is a tough one. I did consider all of the character evidence that is presented on a vehicular homicide. And do you know, 88 Thomas, why we only have one
The
vehicular
other
homicide?
counts always have bond, Judge.
No, but I thought there were two people in the car.
There were, Your Honor, and I'm not sure why they only charged it with the one vehicular. However, I'm sure that'll be something that will be considered as the case is being prepared for indictment.
Okay. I am going to set a bond. I'm going to set that bond at 80,000.
Thank you, Your Honor.
So I'm going to leave the remaining charges as they are. I'm going to set this bond at $80,000 with the conditions is that he is to be confined to his home and only leave for the purpose of work, going to the doctor, going to court, going to work. That's the order of the court.
Judge, one thing, if I may, on the confinement issue, the exceptions to the confinement, I have court, doctor visits, and work, obviously. I'd ask for attorney visits. For
Attorney
him to be
visits,
able-
yes.
I'd ask
And
for
I always
church.
add church.
Okay. And then the other thing I'd ask for that sometimes becomes problematic in my experience, when you have those few exceptions, is just to be able to go to the grocery store to get his groceries, to be able to eat and have some supplies at the house while he's there on home confinement.
They have Walmart, Instacart.
Even if it's something just like, once a week on the way home from work or whatever, can stop at the grocery store to get your week's worth of groceries. That would be very helpful. I do know from experience, because I tell my wife all the time that those Instacart and stuff like that gets very expensive. The surcharges and everything that they add on.
Totally agree. 88 Thomas, what's your position on that?
Yeah, I use my personal preference is Amazon, and I think that there are options rather than stopping at a grocery store. You have Instacart, you have Kroger. My mom uses that when she's a senior citizen, and I haven't experienced any extra costs for that. I'm not sure what services you use, Mr. Rafus, but I tend to agree that he can have food delivered.
Or a family member. I want him
ma'am.
to understand, and I want the bond to be that he is to be at home. And so I think that's a little better than being back there. And so things like those types of errands, his family members and all those good character letter individuals will have to help him out with that.
Understood, Your Honor.
All right. Anything further?
Nothing from the state, John.
Nothing from defense, Judge.
Thank you. Good luck to you, Mr. Smith.
Well, that was interesting and compelling, much more than what we normally get out of Clayton County, where they herd them into a hallway, read them the rules, and then line them up one by one against the wall. So, good times. Crazy case, though. Let's go to Ohio. We'll say good morning to Judge Collada. Interestingly enough, if you'll notice in the background, they have their projection screen pulled down, so maybe they're preparing for movie night later tonight. Let's see what's going on.
Gretzky. We are here in two cases of State of Ohio versus Christopher Hallman, case number 25 CR 751 and 25 CR 997. These are two separate cases. We originally set this morning for a suppression hearing, which the state is ready to go forward if necessary. However, the state has made an offer to resolve both cases. That offer being a plea to the indictment in case number 25 CR 751, one count of aggravated possession of drugs, felony of the 5th degree, and a plea in case number 25 CR 997 to count 2, discharge of a firearm on or near prohibited premises, felony of the 3rd degree, with an amended firearm specification Code Section 2941.145, which would remove the language that the defendant had previously been convicted or pled guilty to a firearm specification, which would make it a mandatory 3-year firearm specification. Defendant's present in the courtroom represented by Mr. Hinton. All discovery has been provided to defense counsel. It's my understanding at this point the defendant wishes to accept the offer. Additionally, the state has agreed to recommend 5-year prison sentence for a resolution of both cases.
Well, my understanding was a joint recommendation.
Correct.
Yes, it's a joint recommendation.
Mr. Hinton, is state's recitation here accurate regarding the discussions you've had with her in attempts to resolve this matter?
Yes, Your Honor.
Thank you. Mr. Hallman, were you able to hear what the prosecutor had to say regarding what she believes your intentions are here at this time?
Yes, sir.
She indicated to the court she believes that your desire to withdraw your previous enter pleas of not guilty in each of these cases. And in case 25-751, plead guilty to the indictment, which is in felony 5, aggravated possession of drugs, the forfeiture specification. And in case 25 CR 997, you are going to be pleading guilty to count 2 with an amended firearm specification of 3 years instead of the 4.5. The other counts would get dismissed. We will proceed straight to sentencing, where a joint recommendation is being presented to the court that an overall prison term between both cases of 5 years be imposed. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you, if at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to speak with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything that's going on with both cases, all right?
Yes, sir.
And when I ask you these questions, especially when I'm talking about your rights, they apply to both cases. I'm only going to go over them one time, but both the rights I'm telling you apply to both cases. If anything applies to one case and not the other, I'll make sure I point that out. But otherwise, and I don't think that's the case, but otherwise everything applies to both cases, all right?
Yep.
All right. Give me 1 second. All right, let's get started then. How old are you, sir?
42.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came to court here this morning, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, you would have received a copy of the indictment in each of these 2 cases previously. That's the documents that set forth the charges in each of these cases. Do you remember getting that at some point for each case?
Yes.
And at some point, did you have the opportunity to review those indictments?
Yes.
All right, in regards to the first case, 25 CR 751, you're charged with 1 count. What's alleged here and what you're admitting to is on or about May 14, 2025 in Mineral Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine. It's a Schedule II controlled substance, and the amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1 of this case?
Yes, Your Honor.
Any questions about it?
No.
Now, the charge also carries with it what we call a forfeiture specification that alleges that during the commission of the offense you possessed or had an interest in property that was considered to be contraband. Contraband is property that is illegal to possess just because of the nature of the property. In this case, it's alleged it contrabands the methamphetamine. The purpose of this is that you forfeit any interest or ownership you have in that property. It doesn't increase the potential penalty you face. It just allows the state to be able to dispose of the property. Any questions about it?
No.
Now, in case 25 CR 997, you're charged with 6 counts. You're pleading guilty to one of those counts, count 2. And what's alleged here in count 2 and what you're admitting to is on or about June 10th, 2025 in Eastlake, Lake County, Ohio, that you did discharge a firearm upon or over a public road or highway, and that conduct created a substantial risk of physical harm to any person or caused a serious physical harm to property. That conduct constitutes the offense of discharge of a firearm on or near prohibited premises. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes, Your
Any
Honor.
questions about it?
No.
So which one's he pleading to here? The second one amended?
Yes.
Specification.
Now there's 2 firearm specifications that are a part of this count as charged. You're not pleading to either though that's charged. You're pleading to an amended firearm specification. It's the second one pursuant to 2941.145. And what you're going to be pleading to is that you had a firearm on or about your person or under your control while you committed the offense that I just read to you, and you displayed the firearm, brandished the firearm, indicated you possessed the firearm, or used it to facilitate the offense. So that's the firearm specification you would be pleading to, which will require a 3-year mandatory prison term, and I'll explain that more in detail in a second. The firearm specification itself, as charged, further alleges that you had previously pled guilty to a firearm specification in another case. That's being dismissed or deleted or amended from that language. If that was in there, the firearm specification would require a 54-month prison term of 4.5 years. By deleting that language or amending that, it reduces it to 3-year firearm specification. So that's what you're going to be pleading guilty to. You understand the difference between what you're charged with and what you're actually going to be pleading guilty to?
Yes, Your Honor.
Any questions about that?
No.
And the first specification will be dismissed as well as all the other counts in the indictment. Is that your understanding as well?
Yes, Your
Do you have
Honor.
any questions about any of those other charges?
No.
Well, then before I can accept your guilty plea to the charges and specification that I just read to you, I need to make sure again you understand all the rights you are giving up. And you first of all have a right in each of these cases to have a trial. A trial could be to me as a judge where I listen to the evidence and I make the ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then the jurors would make that ultimate decision. That ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of these charges. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to have a trial and a jury trial?
Yes.
Now, if we did have a jury trial, or any trial, even a trial of the bench, you'd have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you free of charge. You understand that?
Yes.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty or presumed innocent of all these charges. And the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since it's a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
You understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that, the state would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and that's called cross-examination. He would be allowed to ask them anything he wanted to, within certain rules. Do you understand that?
Yes.
You understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. I'm not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
You realize you're giving up that right?
Yes.
Now, you'd also have the right at trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here, she's not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Lastly, if we were to go to trial and you would be found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding. By pleading guilty here today, you're giving up any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues that you raised or could have raised up until this point. And that specifically applies to the suppression motions that you have filed. In each of these cases, your attorney has filed a suppression motion, which he is requesting. He's alleging that your constitutional rights were violated in some manner, and that as a result of that, certain evidence should be prohibited. The state should be prohibited from presenting certain evidence at any trial that was obtained in violation of your rights. And we have a hearing scheduled this morning on one case to address that, and we have a hearing scheduled on another case, on the other case at a future day, to address those issues. With the plea of guilty here today, you're withdrawing those motions, meaning you're not going to be challenging that issue, and you give up and waive any right you have to challenge it down the road. By pleading guilty, you've given that issue up. You understand that? And we're not going to argue about that or raise that. You're not permitted to raise that later. Do you understand that?
Yes.
And that's what you want to do. Is that correct?
Yes.
All right. Well, do you understand all these rights I've just discussed with you? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Now, do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes.
Now, in regards to case 25 CR 751, that's the drug case. That charges a felony of the 5th degree, which is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in the range of 6 to 12. Do you understand that?
Yes.
Now, in case 25 CR 997, you're pleading guilty to a felony of the 3rd degree. This offense is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, or 30. So if a prison sentence is imposed, which it will have to be in this particular case, I'm going to select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'll be the number of months in prison that you have to serve for this case. You understand that?
Yes.
Now, this case also carries with it that amended firearm specification. That firearm specification as amended will require the court to impose a mandatory prison term of 3 years, which must be served prior to and consecutive to any other prison sentence that gets imposed in this case. Do you understand that?
Yes.
Consecutive means at one after another. So you serve 3 years first, and once that's completed, then you'll serve whatever the prison terms are that are imposed by the court on the other counts. Do you understand that?
Yes.
Now, do you have any other charges pending against you anywhere?
No, not to my knowledge.
I understand you're on post-release control when this happened?
Yeah.
Any other supervision, probation anywhere? Or?
No.
All right, I need to advise you that when a person commits a new felony while on post-release control, the court who is sentencing you on the new felony, in this case it's me, has the discretion to terminate or end your period of post-release control and impose an additional prison term of either 12 months or the amount of time you have left on post-release control, whichever is greater. How much more time do you have left on PRC?
I'm not sure.
Okay. Well, if it's more than 12 months, then we would figure that out. That's what I was, and I don't have to do this, but I have the discretion to do this, and I need to make sure you understand that. But you can be sentenced to the greater of 12 months or the amount of time you have left on PRC, and that if that happened, that would have to be consecutive to any other prison sentence imposed for the charges or specifications. Do you understand that?
Yes.
All right.
Your Honor, I do have a number that I believe is left on PRC.
What is that?
695 days.
That's left?
Yes.
Right. So I could sentence you to an additional 695 days in prison, which would have to be consecutive to whatever prison sentence is imposed. Again, I'm not required to do that, but I do have the authority to do that. You understand that?
Yes.
Thank you. Now, this is not, I didn't look, it's not an offense of violence?
No, it isn't.
Okay. If a prison sentence is imposed, well, let me stop for 1 second. I want to make sure you understand. I'm required to make sure you understand the maximum sentence you face. So in this particular case, the maximum sentence you face, if I imposed the maximum sentence for the discharge would be 3 years, and that would have to be consecutive to 3 years for the firearm specification. So it would be a 6-year prison term that could be imposed in this case. You understand that?
Yes.
And then I do have the discretion to run the prison term imposed in this case concurrent or consecutive to the drug case in 751. So both cases together, you're looking at a maximum possible prison term with the charges you're pleading to of 7 years. You understand that?
Yes.
Plus the possibility of the PRC violation that I explained to you. Any questions about any of that?
No.
All right. Now, upon your release from prison in either of these cases, you could be placed on post-release control for these cases. It's not mandatory. It's up to the parole authority to decide that. If you are, it could be up to 2 years. That's the maximum. And if you are on post-release control and you ever violated any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the prison terms I've just explained, there's other sanctions that could be imposed. You could be fined in each of these cases. In the drug case, 751, there's a possible fine of up to $2,500. On the discharging of a firearm case, there's a possible fine of up to $10,000. $10,000. So together with both cases, a maximum possible fine of $12,500. You can also be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes.
The drug case also could include a 5-year driver's license suspension. Do you understand that?
Yes.
Or up to 5 years. Also, in regards to the forfeiture specification I explained earlier, any right you have to the property in the specification will be forfeited. Do you understand that?
Yeah.
All right, now a few moments ago I explained on the shooting case, the 997 case, that you are facing a mandatory prison term. What that means is that prison must be imposed and you're not eligible for probation or community control sanctions in that case. Do you understand that?
Yes, Your Honor.
Now in the other case, 751, you're technically eligible for community control sanctions, but before I can impose that or order that, a pre-sentence investigation has to be completed. You're not requesting a pre-sentence report in this case, you're wanting to go straight to sentencing. And you're waiving a pre-sentence report, which means I cannot consider probation in that case. Do you understand that?
Yes.
So you understand a prison term will be imposed.
Yes.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever the lawyers say, whatever anyone says, quite frankly, regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
Very well, then. Do you understand all the possible penalties you face by pleading guilty here today?
Yes.
Any questions for me?
No.
Do you still want to plead guilty?
Yes.
Have you had enough time to discuss both of these cases with your lawyer, have him review the reports with you, discuss whatever issues there may be, answer whatever questions you have?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty? I understand the state has made a promise that they're going to recommend a certain sentence and they're required to live up to that promise. But has anyone made a promise to you that I'm going along with that?
No.
Have you been threatened or coerced in any way to plead guilty to any of these charges?
No.
Are you entering this plea freely and voluntarily?
Yes.
All right, do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No.
Do you need any more time to speak with your lawyer before we go forward with the plea of guilty?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show in each of these cases. We'll do one case at a time. I want you to listen to her because I have some questions for you about that, all right?
Yes.
All right. So let's start with the drug case 751, Mr. Gretzky.
Case number 25 CR 751, the defendant on May 14th of 2025 in Menor Lake County, Ohio, was driving a vehicle when a Menor police officer conducted a traffic stop. The vehicle was eventually searched, and the officer found white powder substance on the driver's seat. The defendant stated he believed it to be cocaine. It was sent to the Lake County Crime Lab and was found to be methamphetamine, a Schedule II controlled substance. The amount did not equal or exceed the bulk amount.
Mr. Hallman, were you able to hear what the prosecutor had to say regarding what she believes the facts would show in 25 CR 751 if we went to trial?
Yes.
And what, if anything, did it say about those facts as she presented them? Are they true? Did you do as she said?
Yes.
Very well, then, regarding count one with the forfeiture specification, charging you with aggravated possession of drugs, a felony of the 5th degree. What is your plea to that count?
Guilty.
All right, let's move on to the next case, 25 CR 997, please.
And in case number 25 CR 997, the evidence would show that the defendant, Christopher Hallman, on June 10th, 2025 in Eastlake, Lake County, Ohio, was following a vehicle on Stevens Boulevard when that vehicle made a turn onto East 354th Street from Stevens Boulevard. The defendant discharged his firearm over the public roadway of Stevens and East 345th. The bullet struck the back of that vehicle where the back window meets the frame of the trunk. The discharge of that firearm created a substantial risk of physical harm to any person or serious physical harm to the property. and the defendant, Christopher Hallman, had a firearm on or about his person that he used to facilitate that offense.
Mr. Hallman, were you able to hear what the prosecutor had to say regarding what she believes the facts would show in this case if we did have a trial?
Yes.
And what, if anything, do you have to say about these facts as she presented them? Are they true? Did you do what she said?
Yeah.
Very well. Regarding count 2, charging with discharging of a firearm on or near prohibited premises, a felony of the 3rd degree with the amended firearms 3-year firearm specification. What is your plea to both of those?
Guilty.
All right, I have in my possession at this time 2 documents. Each are called written plea of guilty and judgment entry, and each of them set forth everything I've just explained to you about your rights and the possible penalties you face in each respective case. Before I can accept your plea, I need to make sure you understand what's in the document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to review these documents with your lawyer. Is that correct?
Yes.
Mr. Hinton, is that accurate? Did you review these with Mr. Hallman, go over them with him, answer his questions?
Your Honor, Mr. Hallman read those, and then I had an opportunity to answer any questions he had.
Is that correct, sir?
Yes.
You read the document?
Yes.
You understand what it says?
Yes.
Do you have any questions for me about either of them?
No.
It also appears in each of these documents that you signed each of them. Did you in fact sign each document?
Yes.
And Mr. Hinton, did you witness those signatures?
Yes, Your Honor.
You as well, Ms. Zagretzky?
Yes, I did, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas. Find the defendant guilty in 25 CR 751 of count 1, aggravated possession of drugs. Drugs being methamphetamine, Schedule 2 controlled substance, a felony of the 5th degree, in violation of 292511 of the revised code with the forfeiture specification. As for case 25 CR 997, I'll accept the defendant's plea and find the defendant guilty of count 2, discharging a firearm on or near prohibited premises, a felony of the 3rd degree, in violation of 2923.162A3, along with amended second firearm specification. The first one's being dismissed. The second one was amended pursuant to 2941.145. The remaining counts and specifications in this case will be dismissed. Mr. Hinton, in regards to, I guess both of these cases, but particularly 751, you're waiving the preparation of a pre-sentence report?
Yes, Your Honor.
Can I see counsel for 1 second?
That's so cute. He broadcasts static when he mutes. That's certainly one way to do it. All right, well, we'll wait here just a moment. While we're waiting, reminder, this will be my last day with you for the next 2 weeks, but the show does not stop in my absence. Michael Groff will be stepping up to host over the next 2 weeks. So please do continue to tune in at the normal time. Enjoy your time with Michael. He is a much better broadcaster than I am, so you probably won't want to give him up after the 2 weeks. But please do show him your support. All super chats and super stickers during the time I'm away go to Michael. So do please give him your support. All right, let's get back to it.
Everything a brief recess here. All rise.
Or maybe we won't get back to it because he just walked away. Let's go back to Judge Anzalone.
All right, Ms. Messer, welcome back. All right, so this is in the matter of the people of the state of Michigan versus Robert Love Jr. File number 20-19918FH. I have John Glazier appearing on behalf of Mr. Love, who is present with his client in the courtroom. And I have Ashley Messer from the Attorney General's office appearing via Zoom. This is the date and time set for sentencing in this matter. Ms. Teskey is also covering for the sentencing as well, Ms. Teskey.
That's correct, Your Honor.
So, Mr. Glazier, I know that this has been adjourned multiple times. Are we ready to proceed to sentencing?
I believe you have paid this off.
No, not sure. I think we got down to like 1,000.
Right, what's the balance, Ms. Messer?
Your Honor, the current balance is $1,471.96.
All right, so Ms. Messer, not often do I have someone as successful and who's worked so diligently to do this. Should I adjourn this out for him to pay it off in full?
I would absolutely be okay with that, Your Honor. He's paying above and beyond his monthly obligation every month and come very far. So I would love to see him get the further reduction.
Okay, so yeah, this case here was that if it was reduced to 0, it would be a misdemeanor. So Mr. Love, January?
Yes, ma'am.
All right, and I've just booked through the rest of the year. So Ms. Adams, could I get a sentencing date for January and then also a notice of hearing for Mr. Love?
Okay.
For January 9th?
January 9th at 8:15 in the morning, and we will give you a notice here in the courtroom, and then I will see you guys back on that day. And Mr.
That's
Love,
perfect.
thank you.
Thank you, Your Honor.
January 9th. at
Yes, sir.
8:15.
All right, short and sweet there. Judge Collada's coming back out. Let's go back there, finish that up.
For a minute, Mr. Love, we'll get that for you.
All right. We had taken a brief recess prior to going forward with sentencing to allow the state to attempt to contact the victim. My understanding is that you did reach the victim. Is that correct, Ms. Zagrodzki?
Yes, Your Honor.
And what did he indicate regarding a victim impact statement and any potential restitution order?
He stated that he would waive any right to make a victim impact statement. He is not seeking any restitution. He's aware he has the right to be here today, does not want to be here, and is okay with the court proceeding to sentencing today.
Okay, thank you. Well, with that said, Mr. Hinton, is there any reason not to proceed to sentencing at this time on your behalf?
No reason not to proceed, Your Honor.
Is there anything then you'd like to say on behalf of your client? We're going to sentence him on both cases at this time, so this will be in regards to both cases.
Thank you. I would indicate that, as the court knows, in this regard as it relates to both cases, there is a joint recommendation of 5 years in prison, 3 of those years being mandatory. I know that both sides put a lot of thought into the resolution of this case and that joint recommendation. While we understand the court does not have to join in that recommendation or sentence according to that recommendation, we would ask that the court does, and we do that respectfully. So we're asking for 5 years in prison, Your Honor. Thank you.
Thank you. Mr. Hallman, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
No, Your Honor.
Mr. Hinton, anything else on behalf of the defense?
No, Your Honor.
Mr. Kresge for the state of Ohio.
This is a joint recommendation for 5 years, Your Honor. As was already stated, the defendant was on parole at the time of the offense, stated the amount of days remaining on PRC, and procedurally he was out on bond in the earlier case when the second case was committed. As evident by the age of the cases, defendant has served prior prison term and has been sentenced by this court to prison previously, most recently for aggravated arson in 2021, which was the case he was on parole for. He has 120 days jail time credit in case number 25 CR 997. and 58 days jail time credit in case number 25 CR 751. If the court wishes, I do have additional criminal history, or due to the, as we've discussed in chambers, this is a joint recommendation as we put on the record.
Yeah, that's
Yes.
not necessary.
Thank you, Your Honor.
Mr. Hinton, I do want to get on the record, though, that at this time, your client is withdrawing the motions to suppress that were filed in both cases. Is that accurate?
That is correct, Your Honor.
And that's what you want to do, correct, Mr. Hellman?
Yes.
Very well, then. This court has considered the particular facts and circumstances of the offenses involved in each of these cases. I did meet with counsel in chambers prior to coming out on the bench initially, and they gave me a summary of what the facts were in each of these cases, in addition to what was put on the record during the plea. And I've taken that into consideration. I've considered what's been said here in court by the parties, the joint recommendation presented. I have some familiarity with Mr. Hallman from the past, and I've taken that into consideration as well. And all of it's considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. For the factors in 2912. No factors indicate the conduct is more or less serious in 25-751. As for count 2, I will note well, I guess that's a part of the additional finding that makes it, enhances it, the fact that the bullet actually struck the car, that's what makes it a 3. So there's nothing indicating to the court that it's more or less serious than the normal conduct that constitutes that offense. As for recidivism factors, the court notes the defendant has a criminal history. He's previously served a prison term. He was on post-release control when he committed both of these offenses. He was out on bond in case 25 CR 751 when he committed the offense in 997. He has failed to comply with previously imposed sanctions ordered by courts. No factors indicate recidivism is less likely. Under 2913B1, the court again notes the defendant previously served a prison term. In case 997, he committed the offense. Well, this is an F3, right? So there's no findings are necessary for 2913B. So for 751, he previously served a prison term. That's sufficient for that. The court finds in each of these cases that prison is consistent with the purposes and principles of sentencing. The defendant is not amenable to available community control sanctions. Therefore, in case 25 CR 751, it will be the sentence of the court. Defendant serve a term in prison of 9 months. He will be given credit for 58 days he's already served. I need to advise you in this case, upon your release, you could be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can return you to prison as punishment for violating the rules for another, this would be 4.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence. This time, the court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, and transfer to transitional control. In regards to case 25 CR 997, it's the sentence of the court that on count 2, defendant serve a term in prison of 24 months. Then in the firearm specification, he served a mandatory prison term of 3 years, which shall be served prior to and consecutive by statute to the prison term imposed for the underlying offense, for an overall prison term of 5 years, with the first 3 being mandatory for the firearm specification. There'll be 120 days credit on this case. The prison term I just imposed, the prison terms I just imposed in this case shall be served concurrent with the prison term imposed in 25 CR 751. I need to advise you in this case as well, same thing, that upon your release you may be placed on post-release control. It's up to the parole authority to decide that. If you are and you violate, and that would be up for could be up to 2 years. If you violate any of the conditions of post-release control, if you are on it, parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half the term I imposed. Any additional prison term imposed in this case for violating post-release controls being imposed as part of the sentence at this time. Defendant's order to pay out costs. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. I will dismiss the balance of this indictment. And also, in regards to the first case, 751, I'm going to order the forfeiture of the contraband, and that was set forth in specification. I forgot to note that. So that will be ordered. As for the consecutive findings in 997, there's no special findings that are necessary as statute requires the firearm specification to be served consecutive to the underlying offense. I also want the entries in each case to reflect that the court adopted the joint recommendation presented by the parties in regards to the sentence that was ultimately imposed. I think that covers everything. Is there anything I've omitted or need to address, Mr. Gretzky?
I don't believe so, Your Honor. Thank
Mr.
you.
Thank you, Your Honor. On the lower case number, we'd ask that bond be released.
Oh, was the bond posted?
It
Yeah,
was.
bond will be released in that
Thank
case.
you.
Yeah. That's right, he was on bond. I only forfeit it when they don't show up, so bond will be released. There.
Okay, thank you, Your Honor.
All right, anything else?
Nothing further.
Thank you.
All right.
Okay, friends, we are not, there's only like 10 minutes left anyways, but we're not going to Dungeon Court today because the capper is not in. It's somebody else and not as intriguing. But we got 10 minutes left. There's not a whole ton going on out there in Courtlandia, but we can go back to Clayton County where they are now putting people up against the wall. So we'll spend our last few minutes there.
Man, I don't want to be tired of the, y'all know what I'm saying. I was just gonna give, you just don't have to be packed up, you just stay morning outside, we can't, God be at breath, you can't be worried what y'all will live, all the stuff, I'm saying.
Sir, it's yes or no.
I don't remember, I got a lot of stuff going on.
All right, I'm going to assign a public defender to represent you, and that will take care of everything today. Thank you, sir.
Come on. All right.
What house are you in?
3. All right, good.
Barbara, thank you for the $5. Finally went through. I appreciate you. Thank you. And yeah, hopefully we'll have a great trip.
The women judge.
Oh, okay, thank you. All right, good morning, ma'am. Can you state your name for me? Ms. Collins. All right. All right, Ms. Collins, you have 2 charges. They're both misdemeanors. There's obstruction. That bond is $1,000, and there's providing a false name, address, or date of birth. That's $1,500. So your total bond is $2,500. The preliminary hearing will be November the 18th at 8:30 a.m. And I am going to see that a public defender is appointed to represent you, and that'll take care of everything today. Thank you, ma'am.
Hey.
All right, and good morning, ma'am. Can you state your name for me?
Good morning. I'm Kimmy Daly.
All right, Miss Daly. You've got 2 charges. These are both misdemeanors. There's criminal trespass. That bond is $1,500. And there's obstruction of law enforcement officers. That bond is $1,000. So your total bond is $2,500. While out on bond, you are to stay away from and have no contact with Hannah Batchelor and Haley Batchelor. It's my understanding you all live at the same residence. Is that correct?
No, sir. That is my home where me and my husband.
Do they live there?
No, sir. They do not no more. That's what led to this.
When did they leave?
It was Friday the 17th, and then they came down here and filed those lies.
So they're not staying there right now?
No, sir. They are not. All of their things have been removed. The police was there to
that's how this charge happened.
Yeah.
Was the removal of their things. So here's how it's going to work. If they are not there anymore, if they have left, then you can go home. If they are there, then you can't be at the home because you have to stay away from them.
Yeah, I got you.
And so just, you know, you can't be around them because that violates your bond and that would bring you back here. Okay. So just stay away from them, have no contact. If they turn out to still be there, I will put into the bond conditions that you can contact the sheriff's department so that they can schedule an appointment where you can go in and get what personal items you need for the time being out of there. Okay. You just have to schedule that within the first 10 days of your release. The preliminary hearing in your case will be scheduled for November the 18th at 8:30 a.m. And
Your Honor, can I ask a question?
I'll let you ask a question at the end here. So I am going to assign a public defender to represent you, and you can go ahead with the question.
Sir, are you able to give me a signature button today?
No, ma'am, not on these charges.
All right.
All right, thank you.
All right, thanks.
Bailey, thank you for the $5 super sticker. Very much appreciate that. Ashley, thank you for the $10 super chat. Have a great trip. Stay safe and stay away from wild animals. We're going to bypass Chicago, so we should be good there. And Bailey, thank you for the $5 super chat. Appreciate all of you so much. Thank you.
Mondinator.
This is Miss Denard.
Denard, okay.
Mary Alice Denard Williams.
Mary Denard Williams, okay. All right, so Mr. Denard, you have one charge, that's criminal trespass. That bond is $1,000. While out on bond, you're not to return to Hartsfield-Jackson Airport unless you have a valid ticket for travel on that day. The preliminary hearing will be scheduled for November the 18th at 8:30 a.m. And I will assign someone, a public defender, to represent you on this case. All right, did you have a question?
Yes,
What's your question?
I need to get my property.
Okay, Ms. Denard.
Where's your property?
My clothes.
Where is it? Where's your property?
They got it.
Who's they?
Airport.
Airport has your property. Well, they may have transferred that to the sheriff's department, but otherwise you can contact the police department there at the airport. Just don't go to the property. You can call them. Okay.
Okay.
Okay. Thank you, ma'am.
What did you want?
All right. Good morning, ma'am. Can you state your name for me? All right, Ms. Head, you have one charge. That's criminal trespass. The bond will be $1,000. While out on bond, you are not to return to Hartsfield-Jackson Airport unless you're in possession of a valid ticket for travel on that day. The preliminary hearing will be scheduled for November the 18th at 8:30 a.m. And I am going to see that a public defender is assigned to represent you. And that will take care of everything for us today. Thank you, ma'am. Good morning, ma'am. Can you state your name for me?
Good morning, Your Honor. It's Mia McConico.
McConica. Okay, Miss McConico. Deputies, can you hold Miss McConico to the end of the women? She's a fugitive, and we'll handle her and the male fugitives at the same time.
Gotcha. Okay.
Okay, thank you. Excuse me just a moment.
Ladies and gentlemen, my daughter Megan just entered the chat. Please say hello to Megan, the bride, the one that we're going to travel for. Hi, Maggie. Good to see you. Yeah, let's hang here just a couple more minutes.
Need to stay away from and have no contact with Leanna Parham for the time being. Do you all live at the same residence?
Right.
Okay, so for the time being, you'll need to stay away from the residence. You can contact the sheriff's department within the first 10 days of your release, and they will give you a date and time that you would be allowed to go in and get what personal items you need. The preliminary hearing will be scheduled for November the 18th. And based on your income level, you do not qualify for the public defender program. So if you'd like an attorney to represent you, you'll need to hire your own attorney, okay? And that will take care of everything today.
I have one question.
Yes, ma'am. Go ahead.
I did went through the eviction for her, but I was waiting on the judge to sign off on the papers so I can give it to the sheriff department.
Mm-hmm.
Is it possible anybody can just sign it? It's been due since August.
That's a whole separate process, different case, ma'am.
Okay, you said the bond was how much?
$1,500.
Okay, thank you.
Okay, thank you.
I didn't hear it all five, but.
All right. Good morning, ma'am. Can you state your name for me?
Mitchell.
All right, Miss Mitchell, you have got 3 charges listed here. And Miss Mitchell, you are in school, is that correct?
Yes, sir.
What year are you?
You said what year?
Yes, ma'am.
Class of 2026.
Okay, so you're a senior this year?
Yes, sir.
Okay. We need to get you back in school and not here in jail, okay?
I want to go back.
All right. So there's 3 charges listed here for you. There's simple assault. Is your family going to be able to help you post a bond and get out?
No, sir. It's only me and mom.
You live on your own? On your own?
No, it's only me and my mom.
Is your mom going to be able to post a bond and get you out of here?
I don't think so. My dad just passed Monday, so it's a lot of stuff going on right now. So I don't really think it's.
Your dad passed this Monday?
Yes, sir.
I'm sorry to hear that. I'm very sorry. All right. So what we're going to do, I'm going to give you kind of a low bond amount on simple assault. I'm going to list it at 1,000. There's a second charge here that is criminal damage to property in the first degree based on the information that I was provided. I'm going to dismiss that charge today. The last charge is obstruction of a law enforcement officer. I'm going to set that bond at 500. So that leaves you with a total bond of 1,500. I am going to check on some things in terms of seeing if I can get the authorization to get you out of the jail without posting a bond. Okay. I don't know that I will get that authorization because this is, there are some allegations here of some violence and simple assault. And sometimes we don't let people out without posting a bond for that. But I am going to check on it when I get done with this hearing. But for now, your total bond will be 1,500. Okay. So if your mom goes through like a bonding company, she may be able to get you a bond by paying about $150 to $225 with that. But I will check on whether we might be able to have you released today. Okay. While you are out on bond, you are to have no contact with Jalen. Well, with the end of, I believe he's a minor. I'm just going to say Jalen. Okay. I'll put his full name in your bond order. The preliminary hearing, we'll schedule it for November the 18th at 8:30 a.m. That will be canceled if you're released from jail. And then you'll get a notice in the mail from state court telling you when to come back. And I am going to see that a public defender gets assigned to represent you on these charges. 18th. Yeah. Okay. So I will check again as soon as I get done with this hearing today. I'm going to check, see if we may be able to just, if I can get the authorization to just get you out. But for right now, the bond will be 1,500. And again, I'm very sorry to hear about your father. Okay. Good luck to you.
Okay, friends, it is that time. It is time for me to go. I hate when that happens. I love spending my time with you guys, but it's time to call it a day. I will be gone for 2 weeks, but the show will continue without me. Michael Groff, I give you the channel. I leave it in your capable hands. You're the best. Thank you so much in advance for all the work you're going to do on my behalf for this community for the next 2 weeks. And please give Michael all your support next week. The show will happen at the normal time, 10 a.m. Eastern, 7 a.m. Pacific. 45 minutes early for channel members, because channel members, I am going to try to do the pre-show from the road. Although Monday I'm going to do it right before we leave, so that'll actually happen here in the TCF bunker, but then after that we'll do it from the road. And it'll be fun. You guys will enjoy a couple of weeks with Michael, and you don't have to listen to me complain about things for a while, so it's a good break for you probably. Thank you so much for all your support today, the super chats and everything. Very much appreciated. Look forward to seeing you all in a couple of weeks. Maggie, I will see you in a week. Thanks for stopping by. Everybody, go have yourselves a great Friday and a great weekend. Take care. God bless.